Good morning. Доброго дня, шановні колеги, хто з України. Поки у нас під'єднуються усі учасники, я з вашого дозволу продемонструю, яким чином ви можете запустити в себе автоматичний переклад і субтитри. Будь ласка, зайдіть в ваш браузер. Збоку там є 3 кнопки. Бачите, 3 крапочки. На них ви можете запустити налаштування. Внизу. В налаштуваннях знайдіть, будь ласка, доступність. Якщо бачите, зліва внизу майже є доступність. Нажміть доступність. І можна включити живі субтитри, обрати мову перекладу, з якої англійська, і на яку мову перекладати українська. Таким чином ви будете розуміти наших англомовних спікерів. Ще раз повторюю, в настройках Chrome ви можете знайти доступність, включити живі субтитри, і в живих субтитрах вибрати англійську і, відповідно, переклад на українську мову. Поки в нас приєднуються всі учасники, дві хвилини почекаємо, поки всі приєднаються.
Вітаю, пане Олександре. Дякую за запрошення.
Доброго ранку, доброго дня. Ми зараз вже всі приєдналися. Так, я дивлюсь, у нас сьогодні зареєструвалося 100 учасників, 101. У нас Володимир Анатолійович, на жаль, виступити сьогодні не зможе, але я вітання від нього передам. Так, ну і у нас за стандартом захід буде проходити англійською мовою. І ще раз повторю, хто тільки що приєднався, ви можете, зараз включу, розширю свій екран, ви можете зайти в налаштування, які є у вас в браузері, внизу налаштування. В самих налаштуваннях вашого браузеру ви можете знайти доступність, там, де чоловічок такий намальований, там обрати живі субтитри. Бачите, коли вибираєте живі субтитри, можна вибрати мову, англійська мова, і переклади субтитрів українською. Таким чином вам вже налаштовані системи штучного інтелекту, які працюють в Chrome, нададуть можливість розуміти і читати субтитри наших англомовних спікерів. Ну, і захід у нас, і україномовні спікери у нас також будуть виступати англійською. Так, у нас 10:05, всі, хто хотіли, мабуть, приєдналися. Тому доброго ранку. Good morning. Let's start our conference, our annual conference, Social Justice and Digital Economy, as a part of Cyber Scottish Week. And I'm happy to introduce our first speaker, our first 2 speakers. Actually, it's famous expert, artificial intellect. So let's listen what our artificial expert want to tell us.
Hello. I'm AI, and I'm pleased to welcome you to our annual conference on social justice and the digital economy. I am here to prove that artificial intelligence is already helping you in science. Now we will talk about artificial intelligence, cryptocurrencies, blockchain, and the state. Our speakers are leading world experts. and you are our listeners who are interested in the development of law and technology. Now I'm translating into Ukrainian.
Вітаю! Я штучний інтелект і рада вас вітати на нашій щорічній конференції «Соціальна справедливість та цифрова економіка». Я тут для того, щоб довести, що штучний інтелект вже допомагає вам в науці. Зараз поговоримо про штучний інтелект, криптовалюти, блокчейн і державу. Наші спікери – це провідні світові експерти. А ви, наші слухачі, кому цікавий розвиток права і технологій. Починаємо!
So our first speaker was artificial intellect expert, and I want to express best words from director of state institution economical legal research named by academic Mamutov, Vladimir Ustimenko. He is unfortunately cannot be today together with us, but our institute share our experience and make events like this in regular basis. And so also today we have just online in record our another organizer, Ukrainian Modern Digital Science head Tetiana Dmitrenko, because she's also cannot be together with us today. So she sent me record. So one minute. Share with you.
Dear participant, colleague, and guest of our conference. Today I have gathered here to discuss one of the most pressing issues of our time, social justice and digital economy. In the era of rapid digital transformation, we are witnessing both new opportunity and new challenges that affect access to technology, the labor market, and social being. Our goals to find balance between innovation and justice, between efficiency and equal opportunity for all. The digital economy offers vast prospects. Remote work, financial technologies, automation, and artificial intelligence are changing the rules of the game. At the same time, we must ask, does everyone have equal access to these benefits? Digitalization should not widen the gap between different social groups, but instead promoting exclusive development and equal conditional for all. Social justice in the digital economy means not only equal opportunity, but also the protect of workers' rights, fair wages, and the creation of a safe working environment. Many digital workers face job instability, a lack of social guarantees, and non-transparent working conditions. We must discuss ways to address this issue so digital platforms become not only efficient but also socially responsible. Furthermore, digital education is a crucial component of social justice. If access to new technology is limited, society risks facing a new form of inequality, the digital divide. Education should serve as a tool that helps people adapt to new realities. upgrade their skills, and integrate into the digital economy, regardless of age or place of residence. Another aspect we must consider is ethical use of technology. Artificial intelligence, big data, and algorithms have the potential to transform our lives, but they also pose risks such as discrimination, privacy violation, and unequal resource distribution. Businesses, governments, and civil society must develop regulation and standards to ensure the ethical use of digital solutions. It is also important to discuss tax justice in the digital economy. Large technology companies exert significant influence on global financial flows. Making fair taxation a critical issue. A fair distribution of the tax body will help support social initiatives, fund education, healthcare, and other essential sectors. The role of the state in ensuring social justice in digital economy cannot be underestimated. Regulatory mechanisms should foster innovation and ensuring equal playing condition for all market participants. Only balanced regulation will prevent monopolization, protect workers' rights, and support economic growth. We must also remember the responsibility of businesses. Modern companies should not only strive for profit, but also contribute to social well-being. Corporate social responsibility in the digital era should include promoting inclusion, sustainable development, and transparent business practices. Today's conference is an opportunity to unite efforts, share experience, and find practical solutions to pressing problems. We believe that social justice in the digital economy is possible. And our task is to turn this idea into a reality. Thank you all for your attention. I wish us productive discussion and collective solution that will help create a further digital future. I wish you to spend this time together with benefits and pleasure. We will definitely see you. Sincerely, Dr. Tetiana Gudima. Bye.
Thank you for this video message from Tetiana Dmytrenko. She's a little busy today, cannot join to us. And I want to read our schedule for today. A first session will be about sanctions, cryptocurrencies, and international law. Our first speaker will be Khrystyna Kanas. She is Ukrainian and English solicitor, PhD, and famous expert in sanction field. Also, next speaker for discussion and question and answer will be myself and Tetiana Gudima, because our Institute of Economical Legal Research of National Academy of Science, one of the deeper research institution which working with sanction regulation, in crypto sanction regulation, and you can find a few articles about this, famous articles by Ruslan Jabrailov, Vladimir Ustimenko, Tetiana Gudima, who work very deep for regulation in Ukraine, in international law, in crypto sanction, and how Russia and satellites fighting against this sanction. Second section will be artificial intelligence and Digital Economy, with our brilliant speaker, James Ramsden KC, King's Counsel. He's barrister and brilliant speaker and court fighter in crypto sphere, and very, very famous lawyer in United Kingdom, and also very famous author of articles in media and popularization for law in cryptosphere as well. And also will be our brilliant speaker, Artemiy Volodin from European International Association of Artificial Intelligence. And after we will speak together about ethic law and artificial intellect using third and last session in this year will be more practical. It's crypto, blockchain, and dispute resolution. Our first speaker will be Dr. Charles Mark. He is for my opinion, one of the best world experts in blockchain regulation and dispute resolution, because Charles collect in one experience China experience, Hong Kong, Stanford University, Oxford University, and Robert Gordon in Scotland University. He is lecturer in Robert Gordon Law School, and he will talk to us special about blockchain-based mediation, smart contracts, and crypto dispute resolution. It's very interesting because now all legal companies in discussion about dispute resolution and litigation in crypto cases and huge crypto cases. Second speaker in third section will be Oleksandr. He is Ukrainian advocate and English solicitor, legal director of Canadis, one of the leader legal company in English market, and his work in crypto litigation, crypto international litigation, and he will share to us experience and practice of English court in this field. And also joined to us in third part, Vlad Sverkun. He is also Ukrainian expert, world-class expert in crypto investigation. He's working with biggest international teams, including Interpol and Ukrainian Department of Cybersecurity as well. And I hope we will have also one expert, Basil Manousos, international forensic expert in third panel. He will also share our experience, and he is a great expert for also in Interpol cases, and brilliant speaker and lecturer who working now in Scotland. And he's just finalized on Basil Marathon. It's famous in crypto and cyber forensic expert, famous event every year. Basil have 24 hours lecture with different speaker and speaking club. So he just called to me and want to join to us when he finish 24-hour marathons, need 2 hours for coffee, and after 2 coffee will join to us as well. So our next speaker will be Kристина Kanas. But before Kристина, I also have some expert about sanction, and I want to give for this expert just 2 minutes for short and brief speech. And if someone have some question, please use a chat for this question for our expert, including our next 2 speakers. Our next artificial intellect expert, and he will talk our opinion about crypto sanction.
Have cryptocurrencies become a substitute in trade turnover, and is it effective to use cryptocurrencies to circumvent sanctions? If at the beginning of 2022 experts said that the crypto market is not able to process Russian currency transactions in foreign trade, now at the beginning of 2025 we see that sanctions aimed at blocking financial flows, They're not working. They are not working precisely because of the development of cryptocurrencies and the attention that the BRICS countries pay to this development. While liberal-minded governments of the Western world are engaged in theoretical discussions about the legal status of crypto assets, the governments of Russia and China have made every effort to ensure that sanctions from the outside world do not affect their economic growth. The FATF recommendations and requirements for identification and verification, on which Western states and providers reasonably and necessarily spend billions of euros, are not implemented by China and Russia in crypto accounts, which gives them priority in terms of time and resource savings. It is noteworthy that cryptocurrencies are used to circumvent sanctions, in particular USDT and a system of offsets through a payment agent, represented by exchanges, in particular, the sanctioned guarantees, or payment services that use its services. The reader may think that this applies only to the black market for crypto assets, but as recent studies by expert groups show, even the white European market is involved in billion-dollar transactions with sanctioned wallets and exchanges. And we will mention this in more detail later. This confirms that the circumvention of sanctions through cryptocurrencies has reached an industrial scale, that the export of oil, gold, and the purchase of necessary goods to circumvent sanctions is carried out through payment gateways in cryptocurrencies, which the Russians do not hide. Analysts in Russia are publicly discussing that all Russian crypto will be marked. Have cryptocurrencies become a substitute in trade turnover, and is it effective?
So after this artificial intellect expert that find all information from open resources about crypto sanctions, I want to ask our next speaker as a professional and not artificial intellect expert, but our colleague is from London, Kристина Ханас. Kристina, welcome.
Thank you very much, Oleksandr. Can you just see my screen? Can I just check?
Yes, see. Brilliant.
Presentation. Thank you. Thank you very much. Thank you for the invitation and the opportunity to speak today. I'm very happy to be here. A little bit about myself. First, just a second. I am Ukrainian, born and raised. I'm a dual qualified English solicitor and Ukrainian advocate. I specialize in cross-border commercial litigation and arbitration with a particular focus on civil fraud disputes. I worked on some of the high-profile cases in the UK dealing with asset tracing and recovery, and I also worked on some major fraud disputes relating to crypto assets. I'm an associate in Australia Group, a special situations, legal and professional services firm in London. We advise on a broad range of matters in dispute resolution, regulatory compliance, civil fraud, fintech and digital assets advisory, and private clients. The topic of my today's presentation is, as you mentioned already, Russian use of crypto assets for sanctions evasion. I will give a brief overview of how the position of the Russian regulators changed in relation to crypto assets in Russia after the war in Ukraine began, especially. And also, I will look at the new Russian legislation relating to crypto assets and crypto mining, and also how all of this and other factors are helping Russia to bypass Western sanctions. Historically, as is widely known, Russia's stance on crypto was changing back and forth depending on various factors. If we go back to 2021 and just the beginning of 2022, before the war, we can see that on the 20th of January in 2022, Russian central bank published a consultation paper which proposed a blanket ban on cryptocurrencies across Russia. They were citing threats to financial stability, citizens' well-being, and sovereign monetary policy. Central bank were saying that crypto assets basically is a financial pyramid, and they warned that it could be widely used to service illegal activities. And Russian Security Service FSB also advocated for the blanket ban, saying that Russians were using crypto to donate to undesirable organizations and foreign agents. So therefore, the central bank has proposed to prohibit all the issue and circulation of cryptocurrency inside of Russia, any trading with cryptocurrencies and creating related financial instruments, and to prohibit cryptocurrency mining in Russia. There was no proposed ban for Russian citizens to hold cryptocurrencies or trade cryptocurrencies abroad. And in the same report, central bank said that Russian citizens, that the volume of transactions, of Russian citizens with cryptocurrencies reached £5 billion in 2021, and that Russia was among the leaders in terms of crypto mining capacities globally. That was 2021, just beginning of 2022. Then a month later, in February 2022, Russia invaded Ukraine, and unprecedented packages of sanctions were imposed on Russia, including SWIFT ban, asset freeze. Major Russian banks were designated. As we know, there was a ban on the provision of high-value crypto assets to Russian persons, which wasn't that very high. I think in October 2022, it was only 10,000 euros, and a ban on the provision of crypto wallets to Russian persons. Fast forward to 2024, and we can see a completely different picture. Crypto mining is now legalized in Russia, and Russia is the second largest crypto miner in the world by its mining capacity. Cryptocurrencies are legalized for the use in cross-border settlements. Putin calls cryptocurrencies a very dynamic and promising directions of the modern economy. And the same central bank now is reporting that as of September 2024, the amount of assets on the wallets of cryptocurrency exchanges belonging to Russian users is over $7.4 billion. So, according to Chainalysis reports and its Global Crypto Adoption Index, Russia rose from the 13th place in 2023 to the 7th place in 2024 in level of embracing crypto after the war with Ukraine had begun. Obviously, sanctions and the complications they cause with international settlements and transactions have been accelerating the use of cryptocurrency in Russia for the third year in a row. And in 2024, as an example, cryptocurrencies worth over $182 billion came to Russia. However, they were saying that the rise in the ranking by 6 positions by Russia is most likely because the Russian government began to actively regulate crypto payments in 2024, thereby opening up prospects for the expansion of legal crypto business. So what was the new legislation in Russia that was passed that promoted the rise of crypto? In July 2024, State Duma passed a law allowing for crypto assets to be used in international payments. The law came into force on the 1st of September 2024, and according to the new legislation, businesses were allowed to use cryptocurrencies for cross-border trade within the experimental regime. And crypto payments trials were set to begin in September 2024, and Elvira Nabiulina, which is the governor of the central bank, was saying that the payments in crypto were set to be done already by the end of 2024. The experimental regime is not public, and the information about its participants and the number of transactions is not being published. So I couldn't find any statistics on how it has operated so far. I did see the Russian Finance Minister Anton Silano said in December 2024, just 2 months earlier, that Russian companies are beginning to embrace cryptocurrencies for cross-border transactions, and that as part of the experimental regime, it is possible to use Bitcoin, which we had mined here in Russia. Silano also expressed confidence that the use of crypto assets in international trade will expand and develop further in 2025. Speaking of experimental regime Rosbank, which is the one of the largest and most important financial institutions in Russia, was said to be pioneering in cross-border crypto transactions, and this is the example of how they propose to operate these transactions. So you can see that Russian companies that would opt to pay for imported goods or services in cryptocurrency would sign a contract with out of Russia supplier. The Russian company would indicate the wallet from which it will pay to the supplier. The out of Russia supplier will issue an invoice that will include the amount due in cryptocurrency and its receiving wallet address. Then the Russian company would deposit the owed amount in fiat cash to its Rosbank account, most likely in ruble. to Rosbank. Rosbank would transfer the money to the third-party crypto exchange or other institution that could buy crypto with the fiat it would receive from Russian bank and would pass it on to the out of Russia supplier. For the third-party provider that specifically mentioned bCrypto, which has since been sanctioned. In November 2024, Putin also signed a law officially designated crypto assets as property in Russia, therefore laying the groundwork for taxation and regulation within the sector. Under the new legislation, mining and selling digital currencies are exempt from VAT, and no taxes apply to organizations facilitating transactions within the experimental regime. So Rosbank, for example, would be one of those. There is a 15% personal income tax on crypto-related profits, and corporate profits from mining are subject to a 25% tax. And last but not least, a law enacted to legalize cryptocurrency mining in Russia, which came into force on the 1st of November 2024. The new legislation requires commercial miners and data center operators to register in a government database, report operations, and comply with regional energy consumption limits. Individual miners can operate without registration if their energy consumption stays below government set limits. And legislation also set guidelines for foreign partnerships and cross-border operations, allowing for Russian mined cryptocurrency to be used for international settlements. Crypto mining is as a big part of the whole scheme of how Russia is trying to bypass Western sanctions. You can see here I'm saying Bitcoin mining as opposed to crypto. This is because 90 to 95% of all the crypto mining activities in Russia are focused on Bitcoin. Russia has recently emerged as the second largest crypto miner globally after the US. The growth of mining capacity in Russia was to be expected, and here are some reasons for this. Russia has vast remote areas with cheap electricity. Crypto mining farms are often based within the sites of the strategic energy objects, such as hydroelectric station or a power plant. Russia has a very cold climate, which allows miners to save considerable costs on cooling equipment for their mining farms. Also, because China has imposed blanket ban on crypto in 2021, it has pushed all the crypto miners from China into Russia. And the sanctions, of course. Russia had to divert its energy flow from EU in 2022 and was left with large excess capacity in terms of energy. So with Bitcoin mining, Russia could offset energy supply losses and convert energy into crypto. Sanctions also put extreme pressure on banking support for Russians inside the country because of the shutdown of corresponding bank relationships and limited ability to make payments outside of Russia. This in turn pushed more people inside Russia to look for ways to convert their ruble-based capital, which was not liquid, into liquid alternatives such as Bitcoin and stablecoins. So Bitcoin mining became a tool for dealing with capital flow control, which basically means spend rubles and get BTC. And also hardware market is very active now, and it's not a problem for Russia to get equipment for mining capacities. In the fourth quarter of 2024, the demand for industrial mining equipment and services in Russia increased threefold compared to the same period last year in 2023. There is also high interest among foreign market participants, including those from the BRICS countries. Here you can see some statistics regarding crypto mining in Russia. Between 2017 and 2021, the revenue from crypto mining in Russia has reportedly increased 18 times, from around $114 million in 2017 to over $2 billion in 2021. Between 2020 and 2023, the volume of industrial mining in Russia has almost tripled. As of early February 2022, and before the Russian invasion of Ukraine and the imposition of unprecedented sanctions on Russia, cryptocurrency worth about $4 billion was being mined in Russia, and Russia had the world's third largest crypto mining industry behind the United States and Kazakhstan. Only a year later, by the end of March 2023, Russia has become the second most powerful cryptocurrency mining company after the United States. In Russia, about 53,000 Bitcoin worth approximately $3.5 billion was mined in 2023. And in January 2025, there were over 136,000 mining farms operating in Russia, and the number of which increased by 7% over 2024. Some more statistics regarding the market of mining. A Russian market is reportedly more diverse in terms of participants and very active on hardware market compared to the USA, which is formed basically by a couple of dozens of large players who have long-term contracts for supply of mining equipment. Russian mining market is formed by four groups, which is hosting sites that were offering plug-and-play solution for Russian and non-Russian clients, strategic players, retail miners, and financial investors with the goal to convert rubles or energy into more liquid capital, such as Bitcoin. The volume of industrial mining in Russia is around 65% compared to the private mining, which is 35%. The largest crypto mining operator in Russia is BitRiver, and it is also the fifth largest in the world. It was opened in 2018 in Bratsk, Irkutsk Oblast, which is ideally located considering freezing temperature in that region and low electricity prices. BitRiver currently operates 21 data centers in Russia with 10 more under construction. BitRiver proudly advertises on its website its close relationships with various Russian government agencies. You can see the list of it, which is a screen grab from its website. The most important or strategic or critical partners for BitRiver, they themselves name as Gazpromneft, Sberbank, and N+ Group. Both Gazpromneft and Sberbank are sanctioned, as we know. N+ Group isn't. N+ Group is the world leader in the production of low-carbon aluminium and renewable energy sources, and the largest private energy holding in the world, with strong links to Oleg Deripaska. BitRiver and N+ Group formed a separate company for collaboration called BitPlus, and due to close relationship with N+, BitRiver has built its facilities and is using resources of the various strategic objects of the energy infrastructure in Russia, like Bratsk hydroelectric station, a hydroelectric dam in Ust-Ilimsk, and others. So it was originally sanctioned, N+ Group was sanctioned in 2018 by OFAC, but then in 2019 they made a deal with Deripaska by which he agreed to reduce his sharing ownership in the company from 70% to 45%, and so N+ Group with its subsidiaries were excluded from sanctions. Deripaska is still under sanctions personally. Recently, also the Russian state and BitRiver unveiled plans to build mining data center across BRICS nations. The partners will focus on expanding the potential of crypto mining data centers with the possibility of further scaling of technologies. The partnership aims to expand Russia's share in the global computing market through construction of high-performance data center equipped for cryptocurrency mining and artificial intelligence workloads. The Russian Direct Investment Fund is involved in the project, and it invested over $22 billion already across more than 100 projects. The fund's CEO, Kirill Dmitriev, added that development of computing power for AI was a priority for Russia and its BRIC partners. So what are the takeaways, or to sum it up, basically? Crypto industry in Russia is booming. It is backed by the state regulators and most powerful players in both energy and banking sectors of Russia, including such companies as Gazpromneft, Rosenergoatom, N+, Rusal, Eurosibenergo, and Sberbank. Russian miners earn billions of dollars a year. The supply of specialized mining hardware to Russia is breaking all records. Russian energy companies affected by the Western sanctions increase their income through crypto mining. They sell their surplus energy to crypto mining companies and generate profits despite sanctions. Crypto mining companies in turn get cheap electricity for their mining operations and create Bitcoin, which is in 2024 only rose in price by 134%. The new legislation passed in 2024 allows Russia to generate large profits in crypto mining industry alone, but this coupled with enabling Russia to use crypto assets, both mined in Russia and elsewhere, in cross-border trade is a golden route to evading Western financial sanctions. Although BitRiver was sanctioned by the US in 2022, it is not sanctioned by the EU or the UK. And being sanctioned by the US, it did not create pressure enough to stifle its operation or profits. None of the other largest crypto miners or data center operators are sanctioned. They need to be designated so that European companies and citizens don't deal with them. And financial institutions that facilitate crypto payments from and to Russia are mostly sanctioned, and they are increasingly involved in trade with friendly to Russia countries such as BRICS. In these scenarios, secondary sanctions are important, including against non-KYC crypto exchanges, crypto mining equipment producers, crypto traders, and exchanges accepting payments in fiat currencies from Russian banks, converting into crypto and passing it on to the non-Russian suppliers, and as well as foreign companies using crypto mining facilities, etc. So these are the very key points. I just wanted to say it's a very wide topic and we could spend days talking about this. But if anything, the key message is the problem is huge and it cannot be ignored. Just remember how many times I said billions of dollars today. But thank you very much for your attention. If you have any questions, please do ask.
Thank you, Christina. It's a really significant report. Actually, for discussion and for answering question session after your presentation, our institute published it in 2 years ago and 3 years ago research about crypto regulation in Russia and ways for protection of Russian assets against sanction. And now you show to us very great progress from Russia legal regulation at first, because legal regulation and legal forecast, of course, it's basis for economical growing. My part of this session, unfortunately, my colleague Tetiana Gudima now have another event in National Academy of Science, but we are both working in this project from Ukrainian part, and also with Tetiana Dmitrenko, who was our first official speaker. We are per many 5 times different documents for Ukrainian government from National Security Council about sanction according to Ukrainian legislation. But now in Ukraine we have no any regulation virtual assets, just according to FATF, anti-money laundering, particularly regulation. But after last act about virtual assets that still not working, and 3 different project bills of virtual asset regulation from last news from Ukrainian parliament and from head of tax committee of parliament, Danilo Getmantsov, they working on the to find better solution, who will be official state regulator, who will be government authority in the crypto market. Because if we open MiCA and sharing British or European experience, mainly it's similar bodies, similar state authorities that regulated financial market or stock market. But our parliament don't want this way. They're looking for opportunity, give this power for National Bank of Ukraine, or create a special government authority to for collect power from Minister of Digitalization and National Bank, and maybe some create something. So we have 5 years fighting for power, 5 years fighting for regulation, and any legal forecast. For example, our aggressor and our occupator, for just 2 years, they jump and show to all world very huge growing of crypto assets, and using these crypto assets also in cross-border economical transaction. And I have also one expert, not international expert, also artificial intellect expert about crypto sanction, and show, I want to show you this is opinion.
Regulation of virtual assets in Ukraine and the implementation of the MiCA regulation. Ukraine is actively implementing regulatory measures for virtual assets as part of the adaptation process to the European Union's markets in crypto assets regulation. According to research by international experts, the most pressing issues in the industry are anti-money laundering, AML, and know your customer, KYC, regulatory and technical, sandboxes, decentralized finance, DeFi, privacy and security. The choice of regulatory framework will have a significant impact on Ukraine's approach to crypto asset regulation. The key challenge lies in defining the level of consumer risk and differentiating regulatory approaches. Based on the type of crypto asset, the MiCA regulation, supported by the National Securities and Stock Market Commission of Ukraine, NSSMC, classifies crypto assets into 3 categories: electronic money tokens, EMTs, asset reference tokens, ARTs, other crypto assets, including those not linked to specific assets or electronic money tokens. While separating crypto assets from financial instruments regulated under Directive 2009/110 EC, MiCA does not exclude the application of risk management frameworks similar to those used for financial instruments. This is evident in mechanisms such as public issuance disclosures, issuer reporting obligations, and prudential oversight by regulators. The evolution of Ukraine's regulatory approach to crypto assets will significantly impact its integration into the global digital economy and the development of a transparent and secure financial ecosystem. Regulation of virtual assets in Ukraine and the implementation of the MiCA regulation. Ukraine is actively implementing regulatory measures for virtual assets.
And artificial intellect cannot react so fast like human intellect. But now we have a situation when global south countries have own crypto project. I talk about MSBDC, that on the umbrella of China government, and successful for, as I remember, in end of November, they provide a successful transaction between China to Thailand, first cross-border transaction. So BRICS countries report about they working together on the one international currency, MSBDC bridge, and they use all technologies and energy from China. And from another hand, Western world and northern countries are still thinking about this is a special things, or this is obligation, this thinking and still in discussion about regulation of DeFi and fighting against ML. For your opinion, maybe Western world should, we'll have 2 ways. One, full control as a China experience, or full control for mining and state support mining and crypto market as in Russia, or we have full open market without any state control like in the United States, or strictly regulation like European Union, where all virtual assets providers should have license, KYC policy, AML compliance. For your opinion, which way better for economy, crypto economy development? Kристина how you think about this? Oh, sorry. Yeah, Kристина, can I repeat a question for you?
Yes, please. Thank you. I just lost you for a moment.
For your opinion, which approach from state regulation better for economic growth? China approach, when all transaction prohibited, when cryptocurrencies for individuals and for company block it. It's a criminal liability if you use some cryptocurrency for individuals in China. But government spent a lot of money, billions and billions yen for development of state companies, state mining servers and blockchain infrastructure. For example, Russia, who have a commercial and government companies who work in this crypto market and use state money for development this, or Western version, Wild West like United States, just pay tax and doing everything, and European version, when everything is strictly, you need to have AML control, KYC control, compliance officer, pay taxes, everything. And for your opinion, which way better for economy and economic growing and for digital economy and for social justice as well?
Yeah. It's a hard question, and I think it depends on the country as well. In China, if you speak about China, I am aware, as I was saying, in 2021 there was a blanket ban on crypto, but I don't think they achieved very far. It's basically all the criminal activity now dealing with crypto, but they're still dealing with it very actively. And some reports even on crypto mining, they were at some point the second largest after US. Now official reports saying it's Russia because it's legal now in Russia, but some reports still said that China is a big part of it, even at the same level or even bigger than Russia is. So if there are proper regulations, I don't see a problem with that. And I don't think we can stop the progress with AI and crypto. People will still be doing it because that's the future. So I think the good regulations at the state level and having effective mechanism to make sure that they are operating legally as it is in the regulations, and make sure that the regulations are developing in the same pace as crypto assets and all the progressive technologies was very important, because sometimes they lag behind. So all the progressive developments pacing ahead, and then the regulations just have to catch up all the time. And that's why it's not always effective in terms of sanctions breaches or the crime activities that's going on using blockchain and AI. But I do think we just cannot hide away and just ban all the new technologies in crypto, including, because all it will mean is just people will still be doing it. It's just more crime will be on the rise.
Thank you. I agree with you. And unfortunately, a crypto world reputation more black and dark. So that's why we provide our events, and this is a conference show that blockchain, it's just a part of, cryptocurrency is just a part of blockchain world, and blockchain world give to society for world for all people more opportunity and more wider progress and economic growing. Not just like cryptocurrency speculation, for example. All of you know today new course and new jumping of Bitcoin today. It's around 79,000 today, not 100. So from one hand, but on the other hand, we have a good example when cryptocurrency became a real instrument of state policy in international trading. We have a wonderful question from Larissa Zhdankina. Thank you, Larissa, for question. Larissa, also Ukrainian advocate and doctor of law and working in Ukraine and in UK, and very famous human rights expert and constitutional law. But I read her question. Sanctions can be more precise, reducing Russia's ability to sustain its war efforts while maintaining pressure for political and economic change. How can international sanctions against Russia be optimized to maximize their effectiveness while minimizing intended consequence? Could you please provide some practical tools? Thank you. As I understand, it's a question to us both. It's a very difficult question because even if we talk about Russian oil assets, ships, oil vessels, for gas and for money on the accounts, fiat money on the accounts, not all country and not all international community support a sanction, and we see it. And crypto wallets and cryptocurrencies more difficult for tracer and for blocking than real money, electronic money, fiat money. But in our last part of conference in third section, we will have discussion with Vladislav Tsverkun, who will show how tracer money, how investigate blockchain transaction, and we will share our own litigation experience. But litigation experience is one hand. If we talk about political pressure and political sanction and political decision in crypto assets, we need to support all international bodies and authorities. Because, for example, biggest Russian crypto black market crypto exchange was established in United Kingdom in Edinburgh, Garantex, and just after National Crime Agency activities and presence of this exchange, they changed location for United Emirates, United Arab Emirates, and they still work. They're still working, and we can see it's in using very simple program for watching for blockchain transaction, and all government know about this. All government know about this situation, and we are and cyber experts reported for this for all regulated. But for my opinion, political decision in crypto sanction, it's just political decision, not legal decision. Now, when we start working in this field as academics, I repeat, our institute economical legal research published a few articles about how we can block and how we can use sanction against Russian crypto assets. 3 years ago, we have another view because development of blockchain infrastructure in Russia not be connection with state assets, with state energy and state support. But for 3 years, we see now very dangerous situation when fiat sanction, maybe just 2-3 months, cannot work because Russia changed the way and use just cryptocurrency for global south countries, for BRICS countries, and it's open for the whole market. And Western sanction give a big support for development of crypto services in Russia as well. Christina, sorry for my long speech. Just what you think about this?
I completely agree. As I say, it's actually sanctions was one of the factors that prompted the development on such a huge scale in Russia, and that's why we see it. And I do think part of the problem is, we cannot, I guess, control Russia's shift to BRICS and other countries, which again they are very vocal about. Well, okay, hostile West doesn't like us, so we'll just focus on different markets, and they are huge markets, Asian countries, Chinese, and in India. But I do think part of this problem is also the Western regulators need to be a little bit more robust, because as I say, for example, in crypto mining, I don't think crypto mining industry is sanctioned enough. That could have been done more, and it's not done. They say the largest crypto operator, BitRiver, it just generates huge profits, and it goes in tandem with all the state energy, oil companies, and banking systems, and nothing huge is being done with that. Yes, US sanctioned, but what about the Europe? What about the UK? And what about all the other crypto miners operators? They're not sanctioned. And so all the mined Bitcoin, all the crypto that's been mined in Russia, it goes to the blockchain being traded and generates again profit that way. So there has to be more robust approach on sanctioning the entities who are involved in sanctions evasion, and also secondary sanctions, as I say, are very important, because if you cannot trace all the companies that are Russian companies that are doing what they're doing, you can always see who is helping them to evade sanctions, like not even Russian companies, but Chinese. All the companies abroad who are involved in this, they are facilitating sanctions evasion, which is a sanctions breach as well. So I would say a more robust approach would help as well.
I agree with you, and more dangerous in all this, what Ukrainian government still not working on the crypto sanctions. After 3 years of full invasion and 11 years of war, we still not work in this field, and unfortunately, in this front line, we have no any success and any successful result, unfortunately. But this is very intellectual front line. This is a job for high top level international law experts, and I'm really happy that Ukrainian expert not just in crypto sphere, also in crypto law, and we are now today collect all of them, most of them who I know in personal, and we can collect our question for Charles Mack, because he has experience also from China side, and also American side, and British experience. So now we have maybe 10 minutes, 10 minutes break for tea, coffee, milky tea in English in England, and maybe Scotch for Scotland participator. And our next panel will be start in 11:20 according to London time, and in 20 minutes past 1 according Kyiv times, and our speaker will be James Ramsden, King's Counsel, barrister, and brilliant expert in artificial intellect regulation and crypto regulation and crypto dispute resolution in practical fields. And also he is my favorite author of article in media about crypto, about challenges with crypto and law. And just my recommendation for our participator from Ukraine, return after 2 minutes brief break, and you should find time for listen James' speech and brief lection about about trends in the digital economy and artificial intelligence and their impact on law. So see you 15 minutes later. Thank you, and please join to us 15 minutes later. Yeah.
economy. I am here to prove that artificial intelligence is already helping you in science. Now we will talk about artificial intelligence, cryptocurrencies, blockchain, and the state. Our speakers are leading world experts. And you are our listeners, who are interested in the development of law and technology. Now I'm translating into Ukrainian.
Вітаю! Я штучний інтелект і рада вас вітати на нашій щорічній конференції «Соціальна справедливість та цифрова економіка». Я тут для того, щоб довести, що штучний інтелект вже допомагає вам в науці. Зараз поговоримо про штучний інтелект, криптовалюти, блокчейн і державу. Наші спікери – це провідні світові експерти. А ви, наші слухачі, кому цікавий розвиток права і технологій. Починаємо!
Hello, good afternoon for everyone. We'll start our second session of our conference, Social Justice and Digital Economy. And after a brief coffee break, we have our second session, and I'm happy to introduce our brilliant speaker for this session, James Ramsden KS. Nice to meet you, James. Also, Artemiy Volodin will be our next speaker from International Association of Artificial Intellect Ethical Use. And now we'll have a lecture from James about trends in the digital economy and artificial intelligence and their impact on law. So be free for question in our chat. And James, good afternoon, and please, welcome.
Oleksandr, thank you very much. It's a real pleasure and a privilege to speak to you all, our Ukrainian friends and colleagues. And I'm always a little nervous when I'm preceded by an artificial intelligence actor, and even more nervous after Oleksandr's very generous introduction. I'll see if I can live up to part of that. I've also noticed that I look slightly different from my profile picture on the first slide, but I blame Scotland, where I've been for the last 2 weeks. Oleksandr will vouch for that. About 8 months ago, I was asked to speak at the Mansion House in the City of London on trends in the digital economy. And it was a meeting mainly of lawyers, and there was lots of black letter lawyerly chat about the detail of digital asset regulation and how the law works or doesn't work. And I came away from that thinking, do you know what? We need occasionally as lawyers to get our heads out of our law reports and our textbooks, and we need to look at the horizon to see what's coming down the road, because that has a huge impact, not just on the law as it stands and whether it works or not, but on how the law should be shaped for the future. And that's really what I want to talk about today, because social justice and the digital economy are real partners. The whole point of DeFi is to democratize money and value so that the millions of people around the world who are shut out from the traditional financial structures have the ability to earn and to trade and to send wealth wherever they want to send it. And we've seen that particularly in India. We'll come to that in just a moment. So it's a great theme for this conference. I like it. I think it's very apt. And I think a wider geopolitical view of what is happening is a really important starting point. So what are the trends in the digital economy? One of the biggest factors that I think we all have to take account of at the moment is the central bank digital currencies. as I said a moment ago, DeFi is supposed to be a democratizing aspect of wealth creation and wealth transfer. But governments are not outside of that. A number of governments have now worked out that central bank digital currencies, CBDCs, are a very important part of their future. Up until the US election, the Biden-Harris administration were fundamentally hostile to digital assets. Gary Gensler, who was in charge at the SEC, very hostile himself. Those people have all gone now. And whilst it's very difficult to predict what the US is going to do, it's likely that the US is going to embrace CBDCs. But for once, they're very late at the party, because the territories who have already embraced CBDCs, and to a very significant extent, are the BRICS economies, and in particular, Russia and China. So let's focus on Russia first, because not only is that, I suspect, of interest to a mainly Ukrainian audience, but in my view, strategically, they are the most important and potentially dangerous player at the moment, followed closely behind by China. So Russia saw the value of a central bank digital currency, a digital ruble, before its full-scale invasion of Ukraine. And I suspect it saw the value of it, not just in the context of that planned invasion, several years in the planning, but also as a disruptor in relation to world trade, and in particular, the world financial systems. The de-dollarization of world trade is undoubtedly one of Russia's agenda. So back in 2022, Russia denominated CBDCs, which it piloted through a couple of banks. VTB and PSB were the first two. And the purpose of those pilots were to see whether this kind of digital currency would float in Russia. And it has, to a significant extent. On a day-to-day mundane level, you can go to a Lukoil gas station and fill your car with fuel using Russian-issued CBDCs. You can pay for phone and internet services with Rostelcom using the same currency. And you can travel on the Moscow metro. But much more important and less mundane is the use of CBDCs in international trade. Because what is essential for a disruptor such as Russia is to be able to avoid the dollar economy, and in particular, the international SWIFT payment system. And exactly a year ago, the Russian Duma passed legislation which set up and authorized an international payment system based on an entirely Russian-owned and governed blockchain system, operated and supervised by the Russian Central Bank. This essentially gives a digital asset wrapper to all sorts of commodities that are very commonly traded across borders, such as precious metals, real estate, and most importantly, corporate debt obligations. So bonds, securities, mortgages, and charges. And rather than have to trade those in the conventional way, which will almost always involve a dollar counterparty somewhere in the world, which engages the US and engages currently sanctions, this system swerves all of those, and it does so very effectively. So digital wrappers and CBDCs are now a critical part of the Russian economy and a critical part, not just of sanctions evasion, but of the de-dollarization of world trade. It is estimated that by 2027, the value of assets traded by Russia using digital tracing whether they are CBDCs or digitized assets generally, will be about 600 to 700 billion rubles. That translates roughly to 7.8 billion US dollars. So it is a huge movement in wealth transfer, and it is completely outside of the regulation of the existing world financial markets and the traditional dominance of the US. Now, whilst that is important, it's crucial that we understand this is happening in Russia for obvious reasons, which have direct strategic relevance to Ukraine. We need to be really careful not to ignore other territories. Oleksandr mentioned earlier China. Mainstream digital currencies are, on the face of it, illegal in China, but in fact they are frequently and commonly traded by wealthy Chinese, including many members of the CCP, because they are a very effective way of taking wealth out of China, something that's prohibited. China knows that and is not ignoring it. So China is developing its own CBDCs, and it is piloting its CBDCs and digital currencies through Hong Kong, the closest it's got to a true capitalist economy. And then we come to the BRICS countries. Well, the BRICS countries are, in my view, going to assume huge importance and significance over the next 10 years. The reason is that Brazil, China, and Russia are significant economic players. Brazil and China far more than Russia, but they're significant economic players. Their goal, both politically and economically, is to de-dollarize world trade. And there are three ways in which it's pretty clear they are aiming to do that. The first is the BRICS pay system. I mentioned SWIFT a moment ago. The BRICS pay system was created in 2023 and has taken some time to gather traction, but it is starting to gather traction. And we've noticed this in trades that we've been involved in on behalf of clients, involving, for example, South Africa and India in particular. The BRICS pay system is a direct competitor to the SWIFT payment system, which is effectively regulated and run by the US. It doesn't necessarily need digital platforms to operate within it, but it is intended to be a digital payment platform ultimately, and it will almost certainly be one. If digital assets as a means of moving wealth take off to the extent they are likely to, then the BRICS pay system is likely to become extremely important, because at the moment, the SWIFT system does not admit any kind of digital asset trading. And when you look at the trade generated by Brazil, Russia, India, China, and South Africa, it's easy to see how that system could very easily surmount the SWIFT system. The second big strategic political and economic development from the BRICS countries is the BRICS single currency. Now, as you will know, Britain, the UK, stayed out of the European single currency, almost as controversial a decision as our subsequent decision to leave the EU altogether. Even the most ardent pro-European could not say that the euro has been a consistent success. It has had some successes, it's had some failures. So I've always been skeptical about the BRICS nations issuing a single currency, but I don't think that's what they're doing. I think what they're really up to is to get to a point where they can issue a BRICS CBDC, a digital combined currency. And the reason I think that is that each of the BRICS countries, and India, Russia and China in particular, have spent huge amounts of their central bank reserves buying gold. And up on the screen, you'll see the figures. India, for example, has increased its holding of gold to 841 tons. And overall, the gold reserves held by BRICS members are 6.3 thousand tons. Now, that's getting pretty close to the United States' 8,000 tons, which is literally the gold standard for world currencies. Well, what does that mean? Well, the whole point of a CBDC is that effectively it is a state-backed stable coin. And that means that most states will back their CBDC with gold. It's usually the asset of choice for a central reserve bank. In my view, there is no reason why each of the BRICS countries should be buying gold on the scale they are, unless it is their intention in due course to issue a gold-backed stable coin, CBDC, common to each of them. That would have two significant effects. It would mean trading intra-BRICS, between the BRICS countries, would be very, very easy and cheap. And trading with them, based upon a single CBDC, for non-BRICS countries and companies outside of BRICS, would be extremely attractive. The third way that the BRICS countries are exerting a strategic and political move on the world economic scene is what's been called the BRICS Bridge. And this is essentially a cooperation protocol. And it's all about reducing the cost of trading and world remittances so that trading between themselves becomes easier and cheaper. So the BRICS countries are often forgotten with our obsession, sometimes justified, sometimes not, with the United States and what the United States might or might not do. The BRICS countries often forgotten for that reason, and in my view, dangerously so. I think the next few years are going to see a huge power shift in the world, and the digital economy is going to be a significant part of that. Now, whilst all of that might sound a little gloomy, I think Ukraine has a huge opportunity. It's often said that out of adversity, opportunity arises, and that's undoubtedly right. And it's well known that Ukraine has advanced its technology sector hugely as a consequence of Russia's invasion. And whilst that has been focused, understandably, on military applications, the use of that technology in the digital economy could be a game changer. And there is no question that what I would call the conventional West, the European Union, Southern Mediterranean, and the US, are going to need a strong Ukraine, and a Ukraine that is economically powerful as well as militarily powerful. And I think the digital economy is going to play an important part in that. And I think Ukraine would not just be a part of that, but I think potentially Ukraine could lead that within Europe. Too many of the big Western economies, particularly in the EU, have been very slow to embrace the digital economy. And I think that's got to change. And we see that in particular with economies such as France in the context of AI. So let me move to AI now. We've seen AI in operation already this morning. It is a fascinating development. We are starting to use it as lawyers, and I have no doubt, whether we like it or not, it is going to play a significant part in the delivery of professional services within the next 5 to 10 years. Unlike, from the looks of it, most of the audience, I'm old enough to remember practice as a lawyer before mobile phones and email. And I remember when they were introduced, everybody said, yeah, we'll all be working 2 days a week and earning even more than we are now. Well, it hasn't quite turned out that way. And I think the same is the case with artificial intelligence. It's not going to replace human intelligence, but it's going to make it quicker and more efficient. And that's because however clever the algorithms are, personal judgment, life experience, and emotional empathy are very difficult to replicate in artificial intelligence. But all of that said, economically, it's potentially a game changer. I think it was the Wall Street Journal who estimated that by 2030, the rollout of AI in the US could add 21% to its GDP. We see already half of US mobile phone users using AI on a daily basis. And we see ChatGPT with 1 million users within just 5 days of being made available. We're going to see driverless cars. We've already got mainly driverless agricultural machinery, for example, in the agricultural sector. It's going to have a huge impact on all sorts of sectors. But as I mentioned a moment ago, at the end of the first part of this presentation, there are economies where this is very, very slow to be taken up. And at the bottom right of this slide you're looking at, you can see the difference between the highest take-up of AI platforms, India 59%, UAE 58%, Singapore 53%, China 50%, China perhaps lower than one would expect. But then we see the European laggards, Spain 28% and France 26%. Going back to what I just said, I think Ukraine in Europe has a huge opportunity. So where is AI going to take us? And how is it going to affect the future? The next 12 months, 12 to 18 months, are going to be a very interesting period for the law and AI. Before Biden-Harris lost power at the end of last year, they had sought to introduce an AI Bill of Rights, as they like to call it, which was an attempt to confront AI technology with data privacy. And that is a conundrum that the Trump administration, I think, will just ignore for purely commercial reasons. It's also one that legally and technically is extremely difficult to confront. The only place it's going to be confronted is in litigation. And OpenAI is already the subject of lawsuits in the US alleging the unlawful harvesting of vast amounts of personal data, which is then used by AI platforms for all sorts of commercial informative purposes. Those lawsuits will work their way through the US justice system over the next 12 to 18 months. And in my view, they will determine the future of the battle between AI and personal privacy. I was talking to one of the developers of the Bitcoin network, for whom I acted when they were sued by Craig Wright for about $5 billion US, alleging that they had caused him to suffer an unauthorized hack of the Bitcoin network. These are people who are not really interested in legal regulation, but are code writers, and just brilliant code writers. Their view was that the full rollout of AI is actually just incompatible with data privacy. And if you want your personal data to be private in a new AI world, just don't store it electronically. And certainly don't put it on any publicly accessible network or commercially accessible network anywhere in the world. If you want to store it electronically, have it on a data stick and put it in a drawer. I thought that was quite alarming. And that was a conversation 2 years ago. But several really good technicians in this area have said pretty much the same thing to me recently. And I think that's going to be the big power struggle for AI. AI is economically very important, technologically very important. I think it's going to change the way all of us work, but it's going to rub up against pleas for personal data privacy at every point. And those pleas are important for those of us who live in a functioning democracy. If you don't live in a functioning democracy, they become even more critical, because countries such as China and Russia, North Korea, can harvest all of the personal data they need from open source commercial sources, including data on you and I, people who do live in a functioning democracy, and they can use it for their purpose, which have nothing to do with commercial exploitation or the promotion of democracy. They have everything to do with their own political and military agendas. And that's where strategically data privacy is very, very important. So we'll see which way the US courts go. The US Supreme Court is, of course, now very Trump-centric. I don't think that will necessarily mean that it is going to be wholly unsympathetic to the claimants in those cases against OpenAI. But I don't think we're going to see regulation, particularly in the US, which is aimed at protecting the consumer, if that's going to damage commercial interests. What are the other problems with AI? Well, climate change concerns. Just as Bitcoin mining, crypto mining, uses huge amounts of energy, so does AI. There is also the problem that in a lot of less developed economies, a rush to keep up is going to cause an acceleration in fossil fuel use and a decrease in the amount of sustainable energy used. Another factor is the accelerated speed of innovation. I find this absolutely fascinating. And the Anthropic CEO, Dario Amodei, commented not long ago that he thought that AI would cause what he termed the compressed 21st century. And he theorized that a groundbreaking technological breakthrough would occur every sort of 8 to 10 years, so that in your average century, 50 to 100 significant life-changing technological outcomes will occur. With AI, that is going to accelerate. And I think that's right. That's going to affect medicine. That will affect life expectancy. It's going to affect the speed at which transactions occur, particularly cross-border, going back to the first part of this presentation. With the benefit of AI, CBDC digital platforms can move lightning fast, much faster than they presently do, and they're fast already. So world trade speeds up. We as professionals will be able to perform our functions much more quickly and efficiently than we do now. Physically, goods can be moved much faster than they were before. So the economy will speed up. There are good things and there are bad things about that. Overall, AI is a good thing, but the personal privacy implications cannot be forgotten and are something we are going to have to watch very, very closely indeed. So, where does that leave us in relation to the future? And I'm going to try and draw together both parts of this presentation, because they are linked in a way that I indicated, because there is a lot of reliable intelligence out there which says that China in particular sees the advantage of linking AI to the digital economy, so that effectively world trade is run on algorithm. That is both efficient and so long as it's on the blockchain, entirely traceable. But just as with Russia's world trading platform, the Chinese intention is that all of that algorithm and all of the infrastructure that operates and runs it will be Chinese based. That's what they are aiming for. And some commentators think that China's aim long term is actually to surmount and supersede the BRICS nations. BRICS are a convenient alliance at the moment, but China doesn't really need the BRICS long term. It's the biggest and most powerful economy in the BRICS, and it's politically and militarily the most important member of BRICS. It doesn't really need them. And that's where it's likely to go. So long term, where does that bring us? We have the US on the one hand, which has at the moment a purely profit-driven policy under Trump. If it makes money and it looks good, let's run with it. China, who are looking at the same technology, but for completely different reasons. They are looking at the same technology for strategic and political gain. That might create a collision. It might not. But either way, that for me is going to be the big development, the big conflict, and the big fight to watch in the next 5 years. Who will win it? My hunch is that the US will win it, because US technology and US commercial reach, just like US military reach, is more powerful. And whilst there may be no political will at the moment to flex those muscles across the world in the way that the US has for the last 50 to 70 years, like everything else in the Trump administration, that could change in the blink of an eye. And if US economic interests are threatened, it will change in the blink of an eye, believe me. So not all bad, very exciting. Exciting partly for good reasons, exciting partly for slightly scary reasons. But one thing is for sure, this sector, the digital economy and AI, is entering an amazing phase over the next 5 years. And we as lawyers have great opportunities. You in Ukraine, in my view, have great opportunities. And working together within Europe to make those opportunities work for the benefit of all is going to be the key. And that wider strategic geopolitical vision is what we have to maintain. This may have seemed like a slightly strange address from a lawyer because not much law in it. But before you can make black letter law work for you, you have to understand the geopolitical context in which you're trying to make it work. And I hope this presentation has shone a light on that geopolitical context for all of us, whether we are east or west, south or north, whatever our political beliefs are. It's going to affect us all, and it's going to affect the way we understand and operate the law. So thank you very much. And if anybody has any questions, I'd be very happy to answer them.
James, thank you very much for your brilliant presentation. I have a lot of ideas and use my notebook for everything, but we'll meet later for many questions. I have one question for cross participation to our next speaker from myself. It's your opinion, why United Kingdom don't join to international convention about ethic use of artificial intellect?
Oleksandr, I think the UK has been very slow generally in relation to the digital economy. There is a huge amount of political inertia, which I'm hoping is going to change. Specifically in relation to AI, there is a real fear in the UK about data protection. We have our own Data Protection Act. It was a very controversial piece of legislation when it was introduced in the UK. It still is, for a variety of reasons. We have a very powerful privacy lobby in the UK, not quite as powerful as countries like France, but it's powerful. And I think it's all of those competing political influences which have just caused, as is so often the case, I'm afraid, in UK politics, it doesn't stimulate debate and an outcome, it just stimulates paralysis, sadly. So I think the short answer is it's a consequence of the fact we have quite a poor political class in the UK at the moment, I'm afraid to say.
Maybe it's just careful steps, as a famous British style in politics. Because UK virtual asset regulation may be last in all Europe just last year, when all countries has 5-7 years history of virtual asset regulation. British Parliament not so fast in these decisions.
No. I mean, a lot of countries whom we're happy to boast we gave our law to, like Singapore and Gibraltar, have brought in very good digital asset regulation. And we're still months behind. We have a consultation that doesn't close for another 2 weeks. I can tell you now there's going to be months of navel gazing by politicians in Westminster before anything happens. And from what I've seen of the consultation, it's not very ambitious. So yeah, sadly, if you want to deal in digital assets at the moment, don't deal in the UK. Go to Singapore, go to Gibraltar. Gibraltar's a really good jurisdiction for digital assets. They've got their act together. It's balanced, well thought out, efficient. If we ever get anywhere close to that, I'll be amazed. I'll be delighted, but I'll be amazed.
Great. Thank you. We have one question in our chat from Larissa Zhdankina. She's also Ukrainian academic and advocate. Dr. Zhdankina, we know her very well as a human rights protector. James, can you answer, please? I just wonder, what can you say about how is artificial intelligence reshaping the relationship between the state and individuals in terms of governments, surveillance, and personal freedoms?
It's a great question. Artificial intelligence is likely to be the face of the state in future. Everybody wants to drive down the cost of central government. So one way of doing that is to develop artificial intelligence so that any interaction with the state, whether you're replacing your driving license, applying for a passport, applying for benefits, your tax is a classic example. That could all be done with an AI platform. That's efficient. It's going to save the government money. It might even reduce your taxes. So what's the problem? The problem is that to do that, the government has to harvest as much of your personal data as it possibly can, because artificial intelligence isn't a one-way street. It's only effective if it knows who it's talking to and it knows all about the person or entity it's talking to. That's going to be the problem. And I think your question is particularly apt because it goes back to the point I was just making. And that is, in the UK, we have great sensitivity about personal freedom and personal data and its sanctity. Going back to, we talk about Magna Carta in this country, about the fundamental autonomy of the individual, and all of that is under threat with AI. And people often say, if you've got nothing to hide, you've got nothing to be frightened of. Well, in the most well-run democracies, I think that's nonsense. But very few democracies are well-run. And I'm afraid it's a pretty naive statement to think if you've done nothing wrong, you've got nothing to be frightened of. So I think your question drives at precisely the problem with AI. If it's rolled out and it's going to be efficient and it's going to save time and money, the sacrifice you're going to have to make is your personal data and your personal privacy. And the political question is, Does everybody buy into this, or do people have an opt-out? Do people who just don't want to have their personal data shared, can they opt out of artificial intelligence? That may be the answer.
Thank you. Thank you, James. Our next speaker will be Artemiy Volodin, Vice President of Artificial Intellect, Ethics and Integrity International Association. It's new NGO. I'm also a member of this NGO, and this NGO provides ethical using and popularization artificial intellect approaches in different type of activities. So Artemiy, please, happy to see you. We see, but we don't hear you.
Yeah, I haven't started yet. Thank you, James, for the great presentation. I tried to feed 15 minutes, but hopefully you covered some of my questions just as a support. But yeah, let's start. First of all, a small disclaimer. On the presentation on some of the slides, you might see the QR code. So if my ideas or thoughts resonate with you, feel free to scan and subscribe to a Ethics and Integrity International Association newsletter, and you will have early access to our tools and insights. Okay, yeah, let's start. A couple of words about myself. So my name is Artemiy Volodin. I'm Vice President of the Ethics and Integrity International Association. I have over 12 years of experience in software development as an IT project manager, as well as in ISO standards, where I work as a lead auditor. And thanks to this dual background, I understand both the challenges the companies experience with their development processes and the regulatory issues they face. While keeping those issues in mind, I realized the significant risk AI poses to the society. That is why, together with like-minded colleagues, we founded an association whose main goal is to ensure that development and implementation of AI-based products are ethical and at the same time responsible. But before dive deeper, let's take a look at some numbers. As previously said, AI is going to automate 30% of global work hours across different industries. Up to 375 million of people need to switch occupational categories by 2030. And 72% of companies have already adopted AI in at least one business function. At this stage, these numbers are just predictions. However, AI is growing so fast that in a couple of years, these statistics might be far higher than we expect today. That is why it's crucial to keep a close eye at potential issues and adjust our strategies accordingly. The key issue here is that uncontrolled AI growth can harm an unprepared society. We might have brilliant innovation, but if they are not managed or guided by ethical standards, a lot of things can go wrong. Let's have a closer look at key potential threats. Some of them have been already discussed, but I will provide some more simple samples. So, social inequality. In many low-income areas, people just can't access AI tools or training programs. As AI quickly changes the job market, those without resources won't have an opportunity to adapt, which will make the gap between rich and poor people even bigger. Job displacement. I think no example here are needed. This is just the fact that it will happen. Automated decision making. Even today, some banks use AI to decide who gets loans. Because the system was trained on biased data, it often turned down people from certain minority groups. Data privacy and security issues. A good example here is a smart home device, which might record a bit more than it should, keep the data and potentially share it with third parties. And we can't control it at this point. Bias in algorithms. Imagine an online HR tool that favored male candidates because it was trained on historical data from male-dominated industry. Doesn't sound right. Deepfakes and disinformation. A fake video showed a politician saying hateful things or lies, and thousands of people just believe it was real until experts provided made with AI. And so these aren't just technical issues. They are threats that can harm an unprepared society. By building ethics into AI, we can avoid these pitfalls and create systems that everyone can trust. In order to handle these threats, we need clear, practical, and globally recognized standards. These standards lay out the principles of designing and operating AI systems. They help us judge if an AI tool is fair, safe, and respects people's privacy. But the standards should be supported. And let's take a look at 5 key supporting initiatives that we consider in AI Ethics and Integrity Association. Research and innovation. We need to keep the door open for new ideas and breakthroughs in AI. By supporting open research and trying new approaches that should enable steady progress and push the limits of what AI can achieve. Building a strong community. Here we need collaboration across many minds, developers, business owners, regulators, users. By working together, we can share experiences and come up with well-rounded solutions. And specifically, it's crucial for the standards. Next is concept of compliance registry. Essentially, it's a public ranking of companies that pledge to follow ethical and transparency practices. This registry should motivate companies to meet those standards, since customers can always look into it and see which organizations are truly committed to ethical AI. Next, we must share knowledge about AI. It benefits, its risks. And this education is important not just for companies or software developers or policymakers, but also for society at large, end users, and all the stakeholders. When people understand how AI works and what it can do, they can make informed decisions. And finally, we need tools that let companies and professionals measure whether they are meeting standards requirements or not. Assessment tools can range from a simple checklist to a detailed audit, depending on the complexity of AI system. This will help organizations track their progress and identify areas where they can improve. And each of these solutions for a comprehensive approach to ensure AI benefits everyone, while, of course, minimizing the risks. Regulations. Yeah, we already talked about the regulation during the previous presentation. But here I just want to say that, of course, governments are also looking into AI regulation, most of them, a lot of them. Different countries have their own approaches. The United States and their strong federal push together with numerous state-level laws. The European Union with its proposed European AI Act. Ukraine, China, and others are either drafting or passing AI-related laws. These regulations are important initiatives. However, they are sometimes be slow to adapt to new technologies or might not cover all the edge cases. Because AI evolves faster than legislation, and that's where association like ours can provide real value. We are closer to industry and can act more quickly, adapting the guidelines, offering resources, and providing feedback loops to businesses and users. The most important issue with government regulation is often that lack of agility and their one-size-fits-all approach. By contrast, an association can consult more directly with the companies, adapt standards to different sectors, and educate decision makers on continuous basis. Taking all of this into account, we need to act now before it's too late. AI is no longer a distant possibility. It's a part of our everyday lives, and it will only grow more powerful in the years to come. Yes, so I tried to fit into 15 minutes, so I have even less. So yeah, that's basically it. Thank you for your attention. I hope I gave some, I breathed some light on the current situation with the ethics in AI. If you have any questions or would like to learn more about the association and our approaches and the a roadmap that we have at the moment, feel free to scan the QR code and let's join forces, because at this point we need to group our ideas and move forward with everything we have at the moment. So yeah, thank you very much, and I'm ready to
Thank you, Artemiy. Thank you very much. I just want to talk to everyone that state institution legal economical research of National Academy of Science have a memorandum for cooperation with your association, and that's why we are can give to you legal expertise at best and top level from Ukraine. So we are waiting for next steps and next events together with our institute. So my main question about in our next session, we will talk about crypto investigation. And now very often when two artificial intellect systems meet in one service, for example, in verification in crypto exchanges, very often verification system using artificial intellect meet with fraud companies, fraud criminal artificial intellect who create artificial person with, even now they can make a false person. What do you think the government, which next steps should provide a national level or international level for protect that? Or maybe crypto market should work on this and provide some regulation and like to rules for open market between different exchanges about use artificial intellect against crime and fraud.
Yeah. Thank you for this question. So as James said, but in general, there are limitations that's related to local regulations. And crypto market is a bit outside of most of the governments and regulations in general. And they are free to use AI, specifically face recognition. Now, if you read more about European AI Act, you will see that instead of trying to understand what is behind face recognition technology, they prefer to just assign a high risk to such technologies. On the other hand, this is a great opportunity to identify the potential threats and frauds in users. But so in the future, we will see how these two industries will merge, because each of them can straighten each of the ideas that promote these industries. So yeah, in the future, we might see how we will use artificial intelligence in order to identify fraud. And in addition, maybe to what James said, all the community will be affected. Because, for instance, when governments will start using artificial to identify financial transactions and will process all of your financial accounts, they will try to find whether they can charge additional taxes for what hasn't been filled when you submit your tax fillings. So this is something that poses a huge risk to the society, and this doesn't allow us to keep our asset private. So once it happens, it will bring a lot of stress to all of us. So yes, if you want to keep your private assets somewhere else and protect yourself from AI, you will need just to understand that these assets are not officially related to your personality.
Thank you. Thank you very much. Artemiy, what do you think about artificial ethic use convention? Because after when United Kingdom not joined to this convention, and after some steps from United States, when they go out from different international community and convention, did in this time of some political turbulence, did you have a chance for success join to all countries for this convention?
Potentially, yes. And I think the reason why not all countries at this stage are going to join this initiative is that they are just worried because things go too fast. They need some time to digest all the information, all the facts they have at this point. They don't understand all the specifics of the artificial intelligence. At high level, they might understand what technology behind this, but once they have enough information to make a proper decision, they might join it. But right now, maybe they wait for to see whether there will be created alternatives that will be more reliable for each of the countries. And that's why I think this is reasonable not to hurry up with the decision, but still I think when we don't have alternatives, we need to stick to at least something that potentially can protect the society. So yeah, in the future, in the following years, I think we will see much more initiative that should protect people, their privacy, security, and then we will see whether the United Kingdom and other countries prefer to stick to the current initiatives, or maybe come up with their own, which will be promoted across the world.
Thank you very much. And we have one question in chat from Dr. Sanchenko. Khrystyna Sanchenko, thank you for your question. The question is, it's interesting, maybe you know, that insurance market to offer services in this field. As I understand from your experience, did insurance companies to cover risks using illegal using artificial intellect or different digital risks? Because we have answer from Oleksandr, our next speaker, because he's a top-level expert in insurance support. But for Artemiy question about illegal using of artificial intellect, maybe not that some insurance company covers these risks.
Yeah, so cover the consequences. Yeah, I will share general my thoughts if they are not relevant or just goes against what we will hear next. but I think I'm on the right track with this answer. So I feel like at the beginning, insurance company will do the same as they did with COVID. When we don't understand it and we don't understand how to realize what is behind the issue, they will just prefer to stay outside of this until they realize how they can earn and how they can protect themselves from being frauded from such cases. So yeah, let's see, but I'm sure that most of the companies, insurance, healthcare, financial companies, if they don't understand specifics of the AI, they will be staying outside. So it's related to potential frauds. So yeah, let's see how it goes. But at this point, I think they will stay outside of this question for some time until we have more regulation and be more confident in managing all the issues related to artificial intelligence.
Thank you. Thank you very much. And we'll find a wonderful topic for our next conference about cover the risk in digital economy, because last year we speak about general ways and about crypto regulation development. And this year we add artificial intellect regulation. And in next year we will talk about insurance. I'm sure we can find brilliant speaker for next year. So I see all our next speaker from next session join to us. So Artemiy Volodin, thank you very much. And this session, in second session, was about artificial intellect and trends in regulation. We had a wonderful presentation from from James Ramsden KC, King's Counsel, about trends in digital economy and artificial intelligence and their impact on law. And Artemiy Volodin, Vice President of Artificial Intellect, Ethical and Integrity International Association from Switzerland, about ethical use of artificial intelligence. And thank you very much. I think we don't make a break, and we can start or maybe have 2 or 3 minutes break for next session. I just want to introduce our next panel. Our next panel will be crypto, blockchain, and dispute resolution. Our next brilliant speakers. For my opinion, sorry, I chose these 2 speakers at Charles Mark from Robert Gordon University, Scotland. His collect experience from different university and different school, from Hong Kong, from Oxford, and Robert Gordon, and also, as I remember, Stanford University, Charles, yes. Great. And our next speaker will be Ukrainian advocate and English solicitor, Oleksandr, legal director of Kennedy's, one of the biggest world legal company who working with digital economy and insurance. As I open a small secret, maybe 75 or 80% of all international insurance market is client of Kennedy's. From last 100 years, it's a very old company, and I'm really happy that in this top position, also we have Ukrainian advocates. Maybe we can start without any break between 2 sessions. So, Charles, please, I invite you to your presentation.
Yeah, thank you so much. Can you hear me?
Yeah, I'm here.
Great. Thank you so much for your kind introduction. So good afternoon, everyone. Thank you for joining me today. I'm very excited to be part of this panel discussions alongside with other experts in the field. So many of you already have a solid understanding of blockchain technology and smart contract. Perhaps some of you have even pioneered or contributed to the projects in this space. But now we turn our attention to a subject that often overlooked when new technologies emerge: conflict resolution. Specifically, how do we resolve disputes that arise in the crypto ecosystems in a manner that is fair, efficient, and transparent, and aligned with the very principle that make blockchain technology go powerful? So in traditional business or personal transactions, conflicts are typically handled through offline negotiations, arbitrations, or litigations. But the crypto world brings new complexities. Transactions can cross multiple jurisdictions instantly. Disputes may involve enormous parties, and trust often shifts from centralized institutions to decentralized technology. So with these changes come new questions about how to maintain fairness, consistency, and efficiency in settling the disagreements. So that's where the concept of blockchain-based mediations, smart contract, and the broader arena of crypto dispute resolution center enter into the picture today. So today I will walk you through how blockchain technology and smart contract can integrate into the mediation process, why these integrations can be beneficial, what sorts of challenges may arise, and how we can potentially address those challenges. So before we start, let me begin by briefly introduce what blockchain technology and smart contract are. So even though the audience, I believe, is quite familiar with these concepts, blockchain is a decentralized distributed ledger that records transactions in a secured and a tamper-resistant manner. So each transaction or event is bundled into a block, which is then added to a chain of preceding blocks. So once a block is added, the data is extremely difficult to alter, offering a high degree of transparency or trust in the record-keeping process. So smart contract, meanwhile, is a self-executing contract with a term of agreement written directly into code. Once certain conditions encoded in the smart contract are met, the contract triggers predefined actions automatically. So this can reduce the risk of human error, enhance the efficiency, and provide clarity to all stakeholders. So why does this matter for mediations? Why does it matter for mediations? Traditional mediations relies heavily on paperwork, manual process, and the good faith of parties and the mediators to ensure each step is carried out properly. Integrating a blockchain and smart contract into mediations can provide an extra layer of reliability. Here, the party could record their communications, evidence, and proposed resolutions on a blockchain, guaranteed integrity of the record. Simultaneously, any outcome of the agreement can be enforced automatically through a smart contract, which can eliminate the common pitfalls for non-compliance. So before we explore the specific mediation styles, for today, due to the time constraint, I'm only going to focusing on the most common type of mediations, which is facilitative mediations. Let me highlight the broader notions of crypto dispute resolution. So we're witnessing a surge of disputes that revolve around digital assets, from disagreements over token sales and smart contract failures to controversies about NFT ownership right, DeFi, exploit, and beyond. So the stakes are high, and the parties often span multiple time zones and legal jurisdictions. Traditionally, when there is a cross-border dispute, parties may have to spend considerable resources just figuring out where and how to file a claim. In crypto dispute resolution, we have a unique opportunity to create online border and stack mechanism that leverage the very decentralization that's underpinned blockchain technology. So by tapping into the decentralized identity solutions, escrow services, both powered by smart contract and decentralized adjudications platforms, it becomes possible to resolve the crypto-related conflict far more efficiently than if we were to rely solely on conventional methods like litigation arbitration. So a prime example is the emergence of decentralized dispute resolution platforms. For example, the Clearos, So Cleros is a very famous attack on chain jurors and tokens to incentivize fair decision-making. Another approach is to integrate the blockchain technology into more traditional mediations or arbitration framework, ensuring the final decision is recorded immediately and enforceable on chain. So the bigger point here is that crypto dispute resolution isn't just mediation with a new buzzword attached. It's an entire reimagining of how parties can voluntarily, securely, and transparently settle disputes in a larger online ecosystem. So mediations, as many of you know, can take several forms. Facilitative mediation is one of the most common widespread mediation methods, allowing the parties to maintain control over the process and mediations. So the mediator's role in facilitative mediations is to encourage communications, ask probing questions, and foster the environment in which the dispute parties can discover the underlying drivers of the conflict, identify overlapping interests, and formulate collaborative solutions. So how does blockchain come into play here? First, a blockchain-based registry is certified mediators could exist, decentralized and transparent, so that all potential dispute parties have access to real, verifiable mediator credentials, so which address a long-standing issues, the difficulty to verifying the mediator's expertise and the track record. By sorting details of a mediator's qualifications, experiences, and even success rate on a tamper-proof ledger on a blockchain, parties can make a more informed choice about who will facilitate their discussion in the mediation process. Second, once the parties select a mediator, they can implement a smart contract to handle the administrative aspect of the mediation agreement. For example, if the parties agree on certain rules like confidentiality, timelines, or steps that must occur before the process moves beyond, these can encode in a self-executing contract. Each step in the process can be triggered by on-chain confirmations. A deposit is made into an escrow account. A confidentiality agreement is digitally signed, or a piece of evidence is uploaded and timestamped on the blockchain. So this reduces the administrative overhead and ensure that the parties are aligned on the process. So third, the back and forth communications in the mediations can be securely recorded on a private or permissioned blockchain if the parties so wished. So that way, each protocol, proposal, counter proposal, or piece of evidence is chronologically timestamped, preventing later dispute about who said what or then. So it's really important to know that not all details of the mediations need to be open to the public. Private or permissible chains can help to safeguard confidentiality. The benefit is that the parties, and only the parties, have the unchangeable record of the entire process. So beyond the conceptual benefit, there are tangible ways that the blockchain-based mediations can redefine the dispute resolution in the crypto realm. First, the decentralized dispute resolution mechanism. So if mediation does not produce a final agreement, the parties can automatically escalate the dispute to an on-chain arbitration layer. And jurors are can be randomly selected and incentivized to vote in accordance with the truth. This is something the model used by Cleros. So the entire process is governed by smart contract and hold the release funds, ensure the compliance with final verdict. So the second advantage is secured digital evidence. So crypto disputes often hinge on technical data, wallet addresses, transaction hashes, logs of smart contract development, or NFT records. So storing all relevant data on the blockchain or secure decentralized storage layer like the IPFS ensure that the evidence isn't tampered with, lost or destroyed. A mediator or the arbitrator can easily verify the authenticity of these records, which speed up the resolution process and bolster the integrity. And also it's lower cost as well. So since by automating the various aspects of dispute resolution, crypto mediations or arbitration can significantly reduce the cost. Parties don't have to hire multiple intermediaries or experts to confirm or the validity of their on-chain transactions. And cross-jurisdictional consistency. Crypto markets don't respect geographical borders. A dispute might involve a party in Singapore, another in the US, and the third one in Switzerland. Blockchain-based mediations provide a borderless framework that can bring parties together without the complexities of handling multiple national laws. Though these still require they still need to require the local law compliances. And so, but there are some challenges. While they are integrating blockchain technology and smart contract into mediations and broader crypto dispute resolution holds so many promises, as we have mentioned, advantages, lower cost, it's by no means that there are some challenges. For example, legal uncertainty. In many jurisdictions, the legal standing of smart contract remains quite ambiguous. Court and legislator are slowly catching up, but consistent global framework do not yet exist, and I think they will not never be unified framework across the globe. But the English Law Commission has made something in the distinguishing between the smart contract and smart legal contract, asserting that the smart legal contract can indeed be recognized as a valid legal agreement. Yet, in other regions, in other jurisdictions, no such clarity exists. Disputants, especially those unfamiliar with the local regulations, may be hesitant to trust a blockchain-based process if they are not sure how the court may treat that later on. And also, even the crypto community, there can be some skeptical about the new platform or process. Traditional mediator and lawyers may have concerns about the data security or of the blockchain. Overcoming these cultural and professional hesitations require more education, some time, just need more time to do it. And it's quite complicated, the technology. So this is some kind of challenges. But when there's challenges, there are some strategies that can be solved these challenges. First, legislators worldwide can work out together to create like a model law, like an unsecured model law on blockchain. But I'm not sure it will work because of the political interest among different countries. More training is needed for lawyers, for the stakeholders, even for the parties. So at the first glance, blockchains emphasize the trustless environment might suggest that we won't need mediators or human intervention at all. However, the reality is more complicated. Disputes inherently involve human conflict, emotions, or interactive complexities that code alone cannot resolve. Even in a decentralized system, the mediator role is neutral, empathetic, and solution-oriented. Professional remains invaluable. So mediator helps the parties. So it's needed. Something is required. But for the future, as we look to the future, it's evident that the blockchain and smart contract have the potential to revolutionize the mediations and also arbitrations. They offer the path to greater efficiency, security, and fairness. Elements that are especially crucial in the fast-moving world of crypto. But it's not just about technology for its own sake. It's about strengthening the fundamental principle of dispute resolution, neutrality, accessibility, and voluntariness in a digital context. So this is something we can do in the future, maybe. But and also in conclusion, integrating blockchain and smart contract into mediations under the broader umbrella of crypto dispute resolution is an existing frontier. It aligns perfectly well with the decentralized ethos of blockchain while preserving the collaborative and human-centric nature of mediations. If we do this right, we stand to gain more than just cost saving and faster turnarounds. We have the chance to reinvent the way that people around the world settle disputes, making the process fairer and more transparent and more inclusive for everyone involved. So thank you for listening, and I look forward to discussing these ideas further with you. And I'm going to send you some link of our publications regarding smart contract and blockchain technology. If you're interested, you can read the paper along. I will send you the link on the chat box. Thank you.
Charles, thank you very much. I think we will have some question to you, Mela, as a practical lawyers. Maybe Oleg also will have question to you, because from my opinion, now we have not conflict, but choice for customers between dispute resolution in a mediation way or arbitration way. Because in arbitration, in situation with arbitration, we have a practice, we have a New York Convention first, and second, we have a market, crypto market legal custom when all customers use Singapore International Arbitration Center and Hong Kong International Arbitration Center, and use rules for dispute resolution, American Arbitration Association. So maybe mediation will be, of course, little simple way, but now we have no any regulation, and some model law will be in far future. But now we have very old and very stable instrument as international arbitration for dispute resolution. For your opinion, why mediation can be provide easy and faster than arbitration in crypto market for customers, or maybe it's similar way it just chose for customers?
Yeah, thank you so much for your questions. My answer is it depends. Mediations for some case, especially for small claim cases, they are very useful because they are just faster, more cost efficient. Even in the court in Scotland, especially for a small claim tribunal, they will ask the party to try the mediation first before they go to the litigations. If they do not willing to try the mediation before they go to the litigation, even if they won the case in the future, they will still have some cost sanctions against them. So this is the thing. The reality is courts right now, they are not forced, but they are trying to encourage the parties to try mediations. But in fact, mediations compared with arbitrations, they might be way cheaper, because arbitration right now, they're very similar to litigations in terms of the cost. Some arbitration cases between the state companies, they can last for 7 years. But for mediations, they can be much faster, because in mediations, we are focusing on the underlying interest of the parties in dispute, focusing on the common ground, underlying interest, instead of focusing on just trying to resolve the dispute. It can be more can generate more creative approach, creative way to resolve the dispute. So that's why sometimes mediations is way more efficient than arbitration. But as I mentioned, it depends on the nature of the dispute. If this is a dispute related to investment that involves so many complicated laws, and many jurisdictions, maybe arbitration is a better choice, because they may hire expert witness to provide more advice onto the case. But then we still have evaluated mediations. So I think, yeah, it depends. But thank you so much for your questions. And I saw another questions from
Similar question. What about the cost of such type of mediation?
Yeah. So what about the cost of such mediation? Actually, it will be still cheaper than litigation, because there will be a blockchain. And if you know the technology is rather cheap, it didn't cost much if you know how to do it. But the truth is, not many people are familiar with the technology. Even for me, I just saying it as a theoretical way. I'm not very familiar with the technology myself. And if you need to do it, you need to collaborate with the technological expert. Then they can have a better sense of how to do it on the blockchain. But as far as I know, and I have consulted some of my friends who work in the field as a blockchain expert, the site is quite easily to be done. It can be easily done because it's quite rather cheap compared with other ways. And can mediations be automated in the sense that AI acts as a mediator? I don't think so, actually, because mediation, although AI, they can do many things right now, but interactions, human interactions is the key for mediation process. As a mediator, especially for facilitative mediations, mediator need to build up the rapport with the parties, show the empathy to the parties, and find a common ground for the parties and the underlying interest. As AI, maybe they are not very human, they cannot do such task. Maybe they will just ignore the emotions of the parties, which is not something that the party wished when they are going to try the mediation.
So, thank you, Charles. We have also one question, and I have a question because you have experience work with English law, Scottish law, and Scottish law. It's continental law system, and you have experience also with Asian, China, and Hong Kong law, and very difficult now for Ukrainian lawyers because we also don't have any legal framework about virtual assets, about smart contract form, and especially smart legal contract. And now it's a very big challenge. I agree with a report of English Law Commission about for dispute resolution, we need a special agreement about dispute resolution and also about mediation. For your opinion, can we use one smart contract with additional code that link to model rules for mediation or dispute resolution, or maybe it should be additional smart legal contract?
I think an additional smart legal contract is needed for the process because it will provide extra legal certainty for the parties in the dispute.
Mm-hmm. Because maybe mediation it will be exit from difficult situation, of course, because in crypto markets now we have automatically arbitration between participator in all transaction. If they have some dispute after this, we can use mediation, and after arbitration as a part of litigation, dispute resolution process. But I'm also not sure that artificial intellect can change expert opinion in this case.
Yeah, I agree. Yeah.
Can also one question from Larissa Zhdankina. Charles, I'm impressed. Thank you. Call you kindly share your opinion and of how can we maintain a balance between public and private interest while ensuring the protection and human being, promoting the humanization of governments in the age of AI.
Okay. Actually, if you see the UK law legal system right now, the EU, they do have the AI Act, but in the UK, they don't. I think there is a reason behind that, because in the UK, I think one of the reasons, I think the parliaments, the parliament members, they should know better that we should have a kind of regulations governing the AI. But in fact, they didn't put any regulations. It's because AI is like many other technologies, they are just keep evolving, and we don't know how it will be developed in the future. So I think right now it's really difficult to regulate and really difficult to strike a balance. And I'm not so sure about. It's a really tricky question, honestly. I don't know. In the future, I think in the far future, I'm not sure. Maybe the AI and human will be blurred. The boundaries will be quite blurry. But right now, I think, yeah, maybe some sort of regulations is needed, but maybe some soft regulations instead of some hard law regulation, I think.
Thank you. Thank you very much, Charles, for your expertise and your opinion. We really appreciate your participation. And our next speaker, if you have any question for Charles, let's continue with our next speaker, Oleksandr, and he will show to us our experience in crypto dispute resolution, not mediation, a dispute resolution according to English law. And after Oleg, I'm happy to invite for a next speech Vlad Svirkun. He will show our experience in crypto investigation, and he will show to us new modern soft for how decode crypto fraud and show originally first line and first front line where cyber police fighting against crime, and show how now we can use very modern special system for investigate and provide forensic in crypto cases. But now we will speak with Oleg Shulka. Oleg, you're free with your speech, and we wrote everything and ready for question to you.
Excellent. Thank you very much, Oleksandr. And it's a privilege to be a part of such a distinctive panel. And Charles, that was absolutely fascinating insight into the mediation. But I'm afraid I'm here to talk about the situations when the mediation fails. And people, quite unhappy clients actually calling us to go through the traditional route of dispute resolution. And for the benefit of the audience, I must say that I'm practicing at Kennedy's, and my firm specializes in litigation related to the insurance claims for the, I would say, to the extent of the for the large percentage of the practice. However, we also have a cyber team, and I'm proud to say that we are, for the second consecutive time, being recognized as the best cyber team globally. And I have a benefit to actually speak about absolutely a huge variety of clients' needs and client cases when they reach out to us for the legal advice. And obviously, conscious of time, won't be able to talk about quite a nuanced practice such as digital assets practice here in England, but I would focus on something that might be very relevant for the Ukrainian, in particular, practitioners, where the digital asset space is developing quite rapidly. And as I understand, the Ukraine among the top 5 crypto holders in the world, which means that Ukrainian practitioners in particular should be quite attuned to what is happening in other jurisdictions. And English jurisdiction in particular just happened to be one of the most relevant, given the London role in the global center and the reputation of the English law in the commercial disputes. So I will start with a bit of a statistics so the audience can understand the benefit of the English law system when you have a problem with the digital assets. As you know, we have about $3 trillion or worth of claims annually which relate to crypto disputes matters. This is absolutely fascinating number. It's $3 trillion. And all of those matters I can broadly distinguish in 2 categories. One category is when crypto, if we take crypto as the main digital asset for the purposes of this presentation, crypto is used as fraudulent proceeds, meaning that crypto itself is the subject of the fraud. And when crypto is used as a vehicle to transfer the value obtained by fraudulent actions. Those 2 cases obviously quite distinct because in the first instance, there is someone who is a victim of the fraud when someone stole the keys from the wallet, for instance, and then obviously dissipated the crypto assets to other wallets beyond the reach of the original owner. And in the second situation, when the crypto is used as a vehicle to shift the value, it's just an instrumental situation, and therefore the approach to both of these categories of cases is quite different. But to give you the general understanding where we stand here in England in terms of the legal categorization of crypto assets, this is quite an important thing, and as again for the Ukrainians as well, because I know there is a similar developments going on the ground in Ukraine. So over the past few years, we have quite an important developments that I would like to highlight. The key one actually is the question whether crypto asset can be considered as property. So we have a traditional assets that you have like a tangible, intangible assets, and usually the traditional asset have a physical form, and the digital asset has no physical form, and therefore it's very difficult to categorize or recognize the digital assets as a legal tender, meaning that you cannot attach your rights as you would normally do against the rights of shares or against the right of the house, for instance. But we do have a positive case law, which called AA against person unknown. That's the case of 2009, where the High Court held that crypto asset can be classified as property capable of being subject to proprietary injunction. I will get back to the injunctions later in this presentation, but for the reason of this particular case law, this is the first time in the history of UK judiciary when the digital asset has been recognized as a class of property. And this has been reinforced by the UK jurisdiction task force, we call it UKJT, which issued a legal statement confirming that crypto assets meet the two key characteristics of the property. It's definable, meaning that you can identify what you have, and capable of being owned or transferred. So if you have an identifiable item which costs X amount of US dollars or British pounds, and you've been able to own or transfer this particular piece of asset, that means that's an asset under meaning of the property, and the definition of the property under the UK Civil Code, or English Civil Code for this instance. This is very, very important, and this creates clarity in terms of what kind of object you have or possess, and it creates clarity in terms of your legal rights to defend or recover the asset in case it's been stolen and so forth. So the key distinction to remember is like, unlike shares or real estate, crypto assets are not registered to an individual name, but controlled by private keys. So losing access to a private key means you're losing access to the asset entirely. And that obviously raised the legal questions about ownership rights and assets recovery. And obviously that led to an attached question in terms of the whether software developers have legal duties to restore lost or stolen assets. And I think it nicely attached to the presentation that Charles just delivered, is that can we, as a matter of principle, can we demand the blockchain environment or the blockchain mining subject to remine a particular asset if you lost keys to that particular asset? This is just a rhetoric question, and that's been considered in quite a leading case law here in England, called it Tulip Trading and Van der Waan. That's the case of 2023, and I'm just leave this thought for you to develop yourself. But this is something that I know that Ukrainian colleagues are also thinking about, and I know that Oleksandr can actually give us an answer of this question. as to how some of the players on the crypto market in Ukraine are effectively reissuing coins with the sanction of the legal authorities. I'm abstaining from comments whether this is legal or not. This is something that Oleksandr knows better, but I will focus for this speech focus on the English jurisdiction. So in terms of the key areas of crypto disputes, over the course of my practice, I have like 4 categories, which are the main that I think quite relevant and developing quite fast. So it's usually fraud and assets recovery. That's like a first category, where you have, as I said, you have situations when the stolen crypto or where the crypto used as a fraudulent means. Then you have a breach of contract or the breach of smart contract, actually, if we're talking in the context of the Charles presentation. And there is a situation where you have smart contract with coding errors that caused financial loss. And therefore, the whole point of the smart contract kind of causing the loss to both of the parties. And when parties disagree over the on-chain action, then we're coming to the classic legal resolution measures. Then you have the third category, which is the regulatory disputes. And finally, we have a jurisdictional challenges. So I will cover all 4 for you. And then I will cover how the English court approach crypto cases to provide you the recent update on the case law. Because the case law here in England develops just absolutely amazingly fast. I don't think that we have any other category of cases which I can say are such a dynamic environment. So in terms of the fraud, as I said, that we have a $3 trillion in transactional value and claim value, and I must say that the crypto-related fraud is one of the fastest growing financial crimes here in the UK specifically. The UK National Crime Agency estimated that about 3 billions are lost annually due to schemes of various sorts. This can be like a Ponzi scheme, exchange hacks, phishing scams, ransom payments, all that. So it's like billions of US dollars or pounds. And the UK National Crime Agency is now dealing with this flow of claims. And obviously that requires the English jurisdiction, being quite a sophisticated jurisdiction, for the recovery to react. And English courts have been granting quite a significant case law to support and protect crypto holders and crypto operators. One of the most important features is that English courts have been willing to grant injunctions against person unknown. So injunctions, as you know, it's a sort of a freezing, assets freezing orders, which allow a potential claimant to freeze assets and prevent potential fraudsters to dissipate assets, meaning putting the assets outside of the reach of the potential claimant, until the claimant receives judgment. So in a classic situation, when you have assets to be frozen, you need to identify the defendant. But in a crypto situation, most of the time, you don't know the defendant. You've just been defrauded by someone over there in the web. So therefore, there is a new concept where you can obtain an injunction against person unknown, meaning the unknown defendant in the underlying civil action, which allow victim to freeze stolen assets even when the fraudster's identity is not clear. And this is revolutionary for the civil jurisdiction and still for the common jurisdiction as well, quite a revolutionary step. I must cite the case, so if you're interested of checking, is Ion Science and Persons Unknown. It's a case of 2020. So this is a precedent that we now use to freeze assets against unknown individuals. And that also that nicely connected to the old-fashioned and old classic remedy that English jurisdiction can offer, which we call Norwich Pharmacal Order. This is the instrument which usually used to against third parties to identify whether you have your crypto in this particular instance in the hands of third parties. So to put it in a context, if you've been defrauded, if your crypto has been stolen, and you don't know by whom, so you're acting against personnel known, you can obtain an interim measure with the English court, which we call the Norwich Pharmacal Order, asking the court to compel or to impose an obligation on a third party, and in this instance it's going to be crypto exchange, to disclose account holder information to trace your stolen funds. And that obviously, once you trace the stolen funds, and once you see your stolen funds in some of the wallets or on some exchange in a bank, you can impose a freezing injunction and freeze the asset on the spot, and then you start in your recovery action by way of normal judicial recovery. So again, this is quite a important area of interim measures. And I'm now going back to the previous point of proprietary injunction, and I need to draw the distinction between proprietary injunction and the normal freezing, worldwide freezing order, or just injunction of the assets. So proprietary injunction means that you are freezing the assets which are yours. So I know it's quite a new concept in terms of the equitable interest against legal interest for the Ukrainian practitioners, and being a Ukrainian qualified, I can understand it's hard to understand in terms of the legal framework. But in the English law, you can demonstrate that although your crypto assets has been stolen by the fraudster, it doesn't mean that the ownership title passed to the fraudster. In other ways, so we can allege that the fraudster holds your assets and you are still the owner of the assets, although it's been stolen. And if you can demonstrate that you still owns the title to the asset that's been stolen, you have the equitable title, which allows you to apply for the proprietary injunction, asking the third party, which is a crypto exchange right now, to freeze your assets on the account of the fraudster. This is much easier concept and much lower threshold in terms of the evidential basis that you need to provide and satisfy the court to freeze the asset, because freezing of any asset is quite a serious remedy, because you're preventing the other side of moving the assets around. So the burden of proof on you as an applicant is quite high. And if you can establish that your proprietary right on a particular crypto asset, that makes things quite a straightforward exercise. So turning back to the breach of contracts and the smart contracts. So as Charles said before, many crypto transactions rely on smart contracts, which are self-executing agreements on a blockchain. From my experience, we see two situations where you can have a dispute related to the smart contract, and assuming that mediation for some reason failed, we have two situations. So the one is when smart contract contain coding errors, and that obviously causes the financial losses. So this is kind of a technical situation that you deal with. And the second one is that when the parties disagree over whether an on-chain action satisfies the legal definition of the contract under the law, applicable law, in this instance in the English law. You know that the English law is quite broad in terms of recognition of the contract, and you have elements of contract which you can satisfy even in the situations where two counterparts have oral contract. So offer, acceptance, consideration, causation, that's 4 elements mainly. But when you're talking about the smart contracts, you don't have that exact elements. And therefore, when you have a situation when you cannot resolve a dispute amicably, then you need to reach out to the judiciary to understand whether it is constituted as a contract at all. English law applies traditional contract principles in this situation, meaning that disputes over smart contracts are resolved using existing legal doctrines. Obviously, so you need to understand the elements, so acceptance, consideration, enforceability, and then work with the breach in a normal way. And I think I'm happy to resonate with Charles' remark before, that mediation obviously is quite an advisable tool to use and exhaust before you even reserve to litigation or arbitration. And if we're talking about arbitration as a dispute resolution instrument, it is a precondition for the arbitration to actually try and exhaust all possible amicable means to settle the dispute. Without pre-mediation stage, under the pre-action protocol, it's not advised to go straight to arbitration as a dispute resolution measure. So in that case, obviously, the mediation on a blockchain obviously reduces a lot of nuances and make the whole mediation process quite efficient. So, and the third category, as I said, so we covered 2, right? So we have fraud assets recovery, and then we have a breach of contract, and the third category is regulatory disputes. So here in the UK, we have a financial conduct authority, which has taken an increasingly active role in policing crypto business in general. And many crypto firms operating in the UK must comply with the standard IML anti-money laundering regulations, and the failure to register with FCA can lead to enforcement action straight away. So in that sense, crypto is, although being the distinct and separate financial service, is still kind of considered as a conventional banking or conventional investments or transactional operation, and then you have to obey to the FCA rules and stick aligned with the FCA rules. The UK government is also considering to broader regulation to cover the stable coins, DeFis, and NTFs. Obviously, it's quite a dynamic area. We have a tokenization of the risks as well in the insurance business. So I must say, sadly, that the regulation for all of those fast developing areas are quite behind the actual trading activities. So the players are much more advanced and they encounter much more risks than the regulation can allow us. But that obviously still protected impliedly by the principle of the common law and jurisdictional protection of the assets. So if you don't have a jurisdiction of a particular manner, you still can rely on the principles of a common law, and then you can reach out to FCA for guidance. And that's quite an advisable approach, and we advise our clients to do that and comply as much as possible to 101% with the underlying regulations. And the final thing that I would like to cover in terms of the categorization is the jurisdictional challenges. So this is the entire, this particular topic can actually extend to 1 hour of me speaking because it's such a massive area. So, but I will distill that for your understanding, like in a few things. So because crypto transactions occur on decentralized networks, determining which country's law apply to this particular transaction or in this particular situation is quite complex, to put it mildly. So English courts have asserted jurisdiction when, in 3 instances, when victim of fraud is located in the UK, the exchange holding the crypto asset has the UK connection, and the governing law of a contract, and when we're talking about smart contracts, for instance, is English law. So those 3 categories submit the dispute to the jurisdiction of English court. However, the enforcing the English court judgment in foreign jurisdictions remains a huge challenge. So in practical terms, when you have a crypto exchange or a third party registered somewhere, I don't know, Marshall Islands, and then you have an English jurisdiction for you to freeze the assets of the fraudster, which that third party or the crypto exchange holds, it's virtually impossible to compel the third party to comply with English judgment or English order. So in that means you effectively, although you have an authority from the English jurisdiction, you still need to recognize the same remedy in the jurisdiction where you would like to enforce a particular remedy. And that's very complicated thing, especially when you operate in the less sophisticated jurisdictions of, say, Bermuda, Marshall Islands, and even like Dubai sometimes, and the Emirates in general. This is quite a complex exercise. In Ukraine, on my mind, I think we have quite a few actually successfully enforced injunctions. But the benefit of the injunction is that most of the reliable or big third parties comply voluntarily with the injunctions. What I mean is that if you, for instance, obtain a freezer of the assets held by Binance or Kraken, in 99% of your cases, they will comply with the injunction because they're such a big in reputation as exchanges, and they don't want to appear as not cooperative, not obeying or not complying with the English order or the judgment. In that way, Ukrainian counterparts can also be compliant voluntarily without the need for you to go to Ukrainian court and recognize the particular freezer. But if it's not happening, I'm afraid to say that you need to go through a classic recognition procedure in Ukrainian court or any other court, unless you have a reciprocity principle which automatically applies in such instances. But yeah, just to remember that to tie your case to the UK, in most cases you should have an in personam jurisdiction over the fraudster, or you should have a connection of the fraud to the UK jurisdiction. And by far the instruments of English jurisdictions are one of the most powerful in the world, effectively. So that's why it remains relevant, and that's why English courts and English system they're doing their best to stay on the ball, stay updated, and actually pave the way to categorization of the digital assets as a third class of property. Sorry. So to conclude this presentation, I would like to just remind you with the case law which I referred to. So if you're interested in understanding of the key developments, I refer you to the case AA to a person unknown, which is the first case recognizing crypto assets as a property under English law. The second case is Iron Science and Person Unknown, which is 2020. And that case established the use of worldwide freezing orders to recover stolen crypto. And the final case that I rely on is Tulip Trading on Wonderland, which is 2023, where the court examined whether the software developers have a legal duty to assist users, meaning the crypto holders, in regarding access to lost crypto assets. So on that note, I will conclude, and of course, feel free to familiarize yourself with the Norwich Pharmacal orders, and which is a case, Norwich Pharmacal. So I open the room for your questions. Thank you.
Alex, thank you for your presentation, and maybe we share English experience very wide in Kiev and in Ukraine. Just last just few months, we provide maybe 3 or 4 events for Ukrainian Association of Private Enforcement Officers and show about enforcement procedure according to English law with virtual assets, because now in the continent we have just one jurisdiction, English, where we can work with priority injunction, because in Ukrainian law don't have similar institute, unfortunately. But main question is also how we can choose the English jurisdiction according to case law, because if we have mediation or arbitration agreement, okay, in this case we understand, and Charles showed to us brilliant way to mediation, and also we know arbitration procedure, but in fraud cases or some family cases, family law, and disputes between between former partners, or some investment cases as well, and in dispute between shareholders, when we chose the English jurisdiction, the main trouble is if in continental law we use lex re vitae principle, yeah, now in crypto world lex re contra lit is in English law, as I remember, it's Tulip company with blockchain association case. So maybe you can give to us advice about how we can use English jurisdiction in Ukrainian cases, some 2-3 examples, how we can connect Ukrainian cases in English law.
Yeah, so I see the point of applying the English law in transactions which are happening outside of England, simply because, as we know, the English judiciary system is not exactly reliable, especially for foreign investors who are investing in Ukraine. One of the key considerations they have is that they know that judiciary system in Ukraine is, unfortunately, remains quite unpredictable and I'm afraid to say corrupt. And therefore, if you would like to attract an investor into your project, you need to think about the way how you can assure the investor that any dispute will be resolved in an appropriate fashion. And obviously, English law known to be the most applicable law in foreign investment contracts, and in just foreign investment contracts in general. And if we see the number of transactions which are happening outside of England with the distinction of English law is just fascinating. Obviously, in Ukraine, when we're talking about Ukraine in particular, there is only one limitation that you need to be aware of. The Ukrainian constitution prohibits use of any foreign law in dealings with the Ukrainian state, because that obviously means that the Ukrainian state need to sacrifice part of their sovereignty, and therefore it's impossible, effectively, according to current constitutional terms. But in all other contracts, when you have the foreign element or any foreign element, really, it's not even the English foreign element, you can still choose the English law as a material governing law of the contract. And obviously, for the if you have two parties to the contracts which are Ukrainian, it does not make sense for them unless it's an international trade transaction, because that obviously implies that they need to go to the English court to resolve some very banal local issues. Say you buy the land in Ukraine, you cannot buy land under the English law, but you can distinct your dispute resolution tools to English law as well, in particular, and that there is no provision, to my knowledge, in the Ukrainian legislation that prohibits you to actually apply principles of a foreign law to the transaction or to the contract you have, especially when you have a foreign foreign element. In terms of the practicalities that I just mentioned, it's worth to mention that, for instance, when you have a dispute under Ukrainian law, for instance, you have a breach of contract under Ukrainian law happening in Ukraine, under default rules of Ukrainian material law, you still can apply for interim measure, for instance, worldwide freezing injunction or Norwich Pharmacal in support of your Ukrainian case, assuming that you do have a connection between the potential respondent and the UK. So, for instance, if you have a fraud, but in a classic situation in the context of Ukraine, when you're trying to recover assets that have been stolen, for instance, or been misappropriated by, I don't know, some bad actor, it's very often you encounter that bad actor have some sort of a property in the UK, or maybe they have some attachments to the UK, or bank account, or business in the UK. And then for that reason, you can apply with the application to freeze his accounts or his assets in the UK. So the latest case, which obviously the audience on this call should be familiar of, is the Privat Bank against Kolomoisky Bogolyubov, and I had the privilege of advising Privat Bank on that case, and we successfully applied for an established jurisdiction over the assets of Mr. Kolomoisky in the UK, although there was no connection to the UK jurisdiction per se. We established that connection through the transactional means, and if you're interested, I'm inviting you to read the judgment on that case. But answering your question, Oleksandr, obviously when you have a arbitration clause, you can state the material law of the dispute and the seat of arbitration and the forum of arbitration. When you don't have the arbitration clause, you still can elect the law which will govern the dispute, but there is a limitation to your election. For instance, if you have a counterparty which is state of Ukraine, you cannot do that according to the constitution, or you should have some sort of a connection to the UK jurisdiction, to English and Welsh jurisdiction, to be completely compliant with the language here. There is also a default position of the English courts, and that's we're going to the analysis of forum non-convenience, where you can, even when you don't have a elected clause on the English law, you still can ask the English court to consider a particular dispute, but the other side will raise a defense of forum non-convenience, which is a defensial tool, proving that if the fraud happened in the in Ukraine, or if the fraud happened in other jurisdiction, or the materiality of the contract has been concluded in other jurisdiction, UK should not be the jurisdiction of convenience for the parties. I don't want to go into details on this because this is an entirely separate topic, but I will leave it at that.
Thank you very much. And one question from Kристина Ханас, but just please briefly, we have two next speakers. Are you aware of any English orders enforced in Ukraine dealing with crypto asset disclosure? Cases.
So whether I am aware of any English orders enforced in Ukraine with crypto, interesting question. So by the nature of the freezer and the interim measure, it's not public. So when you enforce in the freezing injunction, it's not exactly privileged and confidential, but the court, to limit the damage of inappropriate freeze, the court incentivized the parties not to publicize the information about the freeze unless the other side agrees, or unless the order is made, and so forth. So it's very hard to track the successful rate of the order, so at least how many parties been attempting to enforce. what I'm aware of is that if you applying with the English court to enforce orders in Ukraine, the asset should be in Ukraine. So that's the underlying principle. Usually, when you apply for the enforcement, the asset in Ukraine. I do have successful cases where the orders been recognized and enforced in Ukraine, but I cannot remember that was particularly related to crypto, because crypto tend to be located outside of Ukraine on some exchanges, as I said, somewhere in Marshall Islands. So there is no underlying need for the applicant to go to Ukraine and enforce the order.
Yeah, it's trouble that we told in the first part of our conference, and our artificial expert, unreal expert told about this, because Ukraine have no still have no legal framework. That's why we have no virtual asset service provider or crypto asset service provider until even if we now apply MiCA, European Regulation Act, but we have no subject to this market, you know. That's why anyone cannot use court order from England in Ukraine. So our next speaker, Oleksandr, thank you very much for your expertise.
Thank you very much for your attention. Thank you.
Thank you. So sorry, we have a lot of questions for you. If someone have some question to Oleg, to contact in person. I'm sure he has best experience in this field. So our next speaker, and I'm really sorry for I asked all of you for individual verification, because Vladislav Tsvirkun will show to us maybe first time in public how crypto investigator working with code, with crypto wallets, and show to us particularly, I hope it's not secret, but not open information, and use a special soft by a global ledger, a Swiss provider. And so maybe it will be most powerful and more useful part of our conference for practice. So Vladislav, please share your presentation and be free with your speech. You have many times, and our participator, please ready for question for Vladislav, because he is working with international teams and Ukrainian cyber police as well as an investigator expert.
Yeah, guys. Hello. First of all, this is the pleasure to share the same panel with guys like Oleg and Charles. It's always a pleasure to hear insights from Oleg, especially for free. So that's why we can give him all the time in the world to give us the consultancies. I'm here on a little bit different side of this. So like
Vlad, sorry, you have some messages in your screen. Maybe it's not so confidential.
We will hide this part. We will hide this part. Thanks for telling. Yeah, that's why
we are not verify all participation for your private mail.
Yeah, last day of the month, guys. What can they do? We need to do those sales. So speaking about what are we doing, we're a little bit different side of this work. So we're more like for you to understand the better, we're like ballistic expertise, that is the private ballistic expertise, let's say. So for you today, you prepared a few things. First of all, I need to explain how our software work, what are the capabilities, what actually we can find, what we cannot find, who we are. Then we will go a little bit about the jurisdiction that is hosting us today, not internet, but the United Kingdom. So we will see what is the danger, what is the main, maybe one of the main problems right now in existence there. And then we will try to make the investigation ourselves, and our software will try to do like a very simple, really fast one, but still it will give you a grasp of understanding how it's done and what is the timing needed, what is the information needed, and etc. So, starting from us. who we are. We started from 2019. We're registered in Switzerland, and through those years, we already been working with many different organizations and law enforcements. The most well-known one will be for sure United Nations, OSCE, Council of Europe. We're very big in Ukraine. I myself in Kiev. Greetings from Kiev to all of you guys. We're here helping and contacted with SSU, with police through different departments, with ARMA, BEP, DBR, and etc. We're trying to be a helping hand for everybody, but of course, we're also trying to conduct business. So that's the thing that was touched today, that Ukraine actually do not have a lot of frameworks, which is a shame. And yesterday I've been speaking with Basil on his cyber marathon, and I was so much advertising the Ukrainian law enforcement and how we're ahead of the world, like fighting those things. Yeah, Basil, there is things that we are a little bit behind, and I hope that the government will actually seek the help of the great people that are here to consult them on those things, since we have an amazing things working in UK and we're trying to throw every investigation to this jurisdiction. The same reason we're registered in Switzerland, because it have all the terminology in place. The same reason we will go to UK if we want to have an investigation case, because they have the proper logic there that is not conflicting with reality of crypto investigations. We work with banks, different businesses, regulators, and law enforcement. For you, the main thing here to understand that if you go to court, again, this is the agenda of the yesterday stuff, and today a lot of people talked about AI. I will say so that you don't want to go to court with AI-based evidences, believe me, because you will need to prove them. And when we're proving something, we need to have methodology or heuristica or anything. If AI made an error, then you will be covering for that. And especially for a company like ours, it's completely unacceptable to collect our database with usage of the AI. We can use AI in a limited way for our OSINT operation, but every evidence, I mean, label that this wallet belongs to this person, this wallet have the tag darknet, this wallet have the tag Hamas or anything, it should be proven by people. Because when any of you will get to court with this, then the another side, right, they will have all rights to question everything, how you collected them. Was it legal? Was it illegal? Was it done by human? How was it done? What is the methodology? And etc. So that is why for you to have an investigation partner, you need to look for companies that provides the full cycle, because the company who provides the full cycle is actually able to finance this data research and methodology and have people for that. Because if you are only profiting from investigations, then it's close to be mathematically impossible for you to collect such a huge database if you are not also helping people to do compliance and other activities. Why we're in the market? We're in the market because we have the difference that separates us from everybody else. That's the private server. That's how we get financed in 2019. So we came in the market, we've seen other companies, and we've been like, well, coming from the letter of the law, you cannot touch anything that touches national security with a cloud-based solution. So we came up with a private server solution, and that's why we're able to work really deep with any kind of law enforcement or special groups, just because they can feel safe that we are not taking their data, and they can trust us. You can trust us, but you don't know what kind of hostings we're using. I'm having coffee every day with them, and I don't know was they breached, was they hacked, or anything. So that is why you need to store your data, and that's the thing that we came to market with. Beside everything that we can find on chain, I know for people in here, the things like on chain, off chain, you're like, what is it? But for us, for people who mostly focus on crypto, we call everything that happens not in the blockchain, off chain. So, and of course, off chain is way bigger than on chain. So with off chain, we collect a lot of information that can support you. So it's not enough for you only to know what kind of business it is or what kind of, I don't know, actor it is. For you, it's important to know where he's registered, what kind of information he is obligated to collect, what kind of information he's collecting, what kind of people is using his service, because he can be registered in the United States, he can be registered in Marshall Islands or anywhere. But then you go in and you see that like 99% of people who is using this service is people from Russia. So maybe it's a shell company or something like this. So that is why we're collecting all this information. And we also in conversation with travel rule alliances, because you need to share data, but your clients never agreed on you sharing data with the third party. So you need to create a new kind of cooperation. And we're gladly supporting them as a data provider there. One further. So the compliance officers, again, they can see everything, register, license, and that's helping not only compliance officers, but that's helping the lawyers, the investigators, and everybody. Because the main idea of all the investigations, if we will simplify it, Charles spoke really well on the DeFi sector, and I will support it. What he is saying is completely true. And we're in many conversations on creating different oracles for different DeFi protocols. And that problem is more like technical. There is only like human will standing like to say, yes, we will implement it, or no, we won't implement it. But if they already implemented it and they have any kind of explorer that we can go through, or they have an proper oracle that collecting the information, then we don't need people anymore there. We already see where the money is going. So the main idea for us, we follow the money. We don't know who's staying behind the money. I don't want to know who, like Me6, for example, is looking for, because I want to live long and beautiful life. I don't want them, you know, to like worrying like maybe Vlad will have a second beer today and tell much more. So that's why we have a private server, and that's why we don't interesting who is staying behind these things. But for you, it could be really interesting. So that is why we're connecting the wallet with funds that are illicit for some reason, let's say. So we're connecting them with businesses that are obligated under, let's say, so global FATF or local jurisdictions like FCA, like WADA, or like it will be MiCA in Europe. So they make them to collect some information. And if they're compliant, then we will just point to you. Do you have an authority? You go ask. We do not have authority. The only people who have authority is law enforcement and attorneys. Unfortunately, right now, the attorney practice is mostly non-existent. So that is why attorneys who are close by the law enforcement, you actually need to make them to go to look for something. And to make them to go look for something, you will need our software, because we will collect this information for you. We will pack it so judge will understand, and he will make law enforcement understand. Also, you can give it to law enforcement. We will add parallel reconstruction part. So the law enforcement will be able to do their job, like, you know, like painting on the papers through the mirror. So it will be completely legit on their side. We can see not only wallets, because wallets is, yeah, you need to follow the money and everything, but when the wallets money goes to business, you need to see the overall picture. And so in our software, instead of just collecting those millions or thousands of wallets of any business and analyzing them one by one and then collecting them in some kind of statistic, for the same amount of requests as you do 50 reports, you can analyze the whole cluster for the quarter in the software. If you will ask from us, we can do any time frame. So basically, we will provide you with the whole analyzation. Could it be Binance? Could it be Garantis, HTX, Whitebit, Bybit? Doesn't matter. We will provide our partners with the whole analyzation on every wallet simultaneously in one report, and it can be also generated inside of our app, which is crucial for regulators, again, like FCA, to not only trust businesses that are operating inside of their region or responsibility though, they will be also able to really verify if it's true what they're saying. So they can see the volumes and they can see the real sources without questioning and relying on this trust to the business. Because trusting the business is cool, but you need to have a way to double check them. You know, it's like one of favorite books like Etiquette of the Banker, that if you are not verifying the numbers, then you are officially letting somebody to screw you over. So that's what can be happening. What's happening in UK right now? What is the main reason why the fraudsters operate so freely? Because imagine you stole the funds from somebody, and then every business you're trying it to send to, they will be like, no, we don't want to deal with it. And you will be just sitting with this wallet in before the police will come to take you to the place where you need to be. But Unfortunately, there is businesses that are operating worldwide, so you don't need to open a door or shop or somewhere so they will come and exchange money. They just need to be reachable through the internet. And even if you will ban them, like you will use different sophisticated services, then there is still dynamic VPNs that will allow you to go there and use those services. So let's first of all to see that one of the main actors right now that allowing the crime in a big numbers to exist in UK and in the world. So I'm going from the side of the business, not from the side of DeFi protocols or different mixers or something, because for us, the business is the worst and the best. So it's the best because they can give you information, and the worst because as soon as any funds reach out Binance, HTX, or any kind of big exchange, first of all, we cannot see where the funds go to, because I go in Bitcoin, it goes to their big wallet that collects everything, and then I want to go out in Ethereum, for example. So we will just use another wallet and we'll get away this transaction. Analyzing the flows of millions and millions funds and connecting the $100, $1,000, $10,000 deposit with the $10,000 withdrawal happening in different blockchains simultaneously with not understandable timing is impossible, because with DeFi protocols, we can test it. We can see how much timing is needed for each action. We can read through smart contracts. So imagine the exchange where instead, or the bank where instead of people, you will just see instructions. That's what basically what smart contract is. So you will see, okay, they will do this, and that. And they have no humor. They have no bad intentions. They just do what should be done. So we can study it and we can go through it without asking anybody. But if it's a business, then they collect everything inside in one wallet or in a few wallets, and they do not give us any kind of hints in before we will question them about it. 1 second, let me kill another messenger so it will not interrupt us. Okay, going further. So one of those things is Garantex. Garantex is somebody who's been sanctioned many times by OFAC, now by European Union. But the problematic here is people who sanction stuff do not really understand how it works. When you sanction the bank account, then it's done, like you want. Like you sanction this, then you go sanction something else, and everything's fine. With crypto, the Garantex, as you understand, they have millions and thousands of wallets, but only 3 wallets in first sanction list was mentioned. Why? Because first of all, a low level of understanding, unfortunately. Second, it doesn't have so much sense. If I will say this wallet is under sanctions, what it will do? He can still transact funds, he can still move with that, he can still find some people who for unreasonable percentage will exchange those funds and carry his risks for him. And if we talk about Garantex, after they became went under sanction, they got the 5x increase in volumes, which means that they're like, okay, we're not in this kind of low system, so we will do whatever we want. And so they became the honeypot for all the criminal activity. And for us, for the investigators, it's a problem, because when the funds go into the binary or something is legal, we can trace what's going out. And we're like, okay, this is something that is not legit. After one wallet, they go to something else and la, la, la. But when it's Garantex, when most of people that use it are either under sanctions or have some criminal associations, then it's like we have thousands of crimes that after one step become the part of one big crime. And we do not know who is watching what. So let's see how do they operate and why do they operate. So after the sanctions, you see this is so just for you to prove it. It's not like they have 1, 2, 3% of something that is not really okay. Everything is not okay there. Most of things not okay there. And so it's more like if you have something legit in here, that is the coincidence and not anything else. So you can see from here that scams, Iran, illegal services, everything made it their home. Even Ukrainian sanctions being avoided by usage of the Garantex. The problem, so the period that we've been overlooking is the whole year, because 2025 only starts, is the October of 2023 and October of 2024. So for that period, you can see that $9 billion was was washed through Garantex, and after that they went to numerous of different OTC that maybe you're aware of, and all of them have Garantex and sources. And the problem is so big that even token providers themselves are not brave enough to have a solution for it. Why? Because Garantex is generating big amounts of volumes they do, and they're interested in this. So we've been in situations where we've been sure that those funds are, let's say, so they're on the way to Garantex, and we had a way to prove it. But still, we were not able to get any answer, even with subpoenas. Subpoenas, of course, been made by Ukraine. We never get any chance to block those funds or anything. More than that, we received a pretty unsatisfying answer that we need to prove that these funds will be specifically used in some specific crime that we should be aware about. So basically what they want from us is to be Vanga for a second. It's I'm like, it's the same thing as if anybody crosses your border with a K-47 and like 100 bullets, and I will need to prove which bullet will actually reach the target. Yeah, like a lawyer, I can joke about it and say like, oh, statistically 10% of bullets reach the target, so we can think that 10% of the, but it's BS if we will be honest. So it's just how it works right now, because we do not have one authority that can really put it to stop. That's for more. FCA does UK is ahead of the world in a lot of things, but are they damaged? So we see 9 billions going over the world. Let's see how much of this funds been actually washed in or allocated to everything that is under FCA. So for the same period, it's 1 billion. So 1/9 of all the funds that have been washed through Garantex is going through the UK associated businesses. We will not, of course, showcase the names of those businesses, because again, we're doing business, but we will show you the statistic. So statistically, the problem of getting funds in is not the biggest problem. So it's not the biggest problem because you can use software as global ledger, and if something is going to you, it means it was on the way for some time. And so this time will probably, but that's not probably, for sure will increase the chances of our to actually catch those funds and identify them, so we can prevent them from going into the business. So the crime happened, but they cannot use those funds, they cannot exchange them, they cannot move with them. So the operation is at least very, very, very much slowed. But where the real problems hides in is in the financing. So businesses in UK actually became the liquidity pools for Garantex. So somebody with fake ID goes into the UK business or Ukrainian business, and then they buy millions, thousands of the assets they will need for their operational activity. Because the reasons why we sanction somebody, we're trying to prevent them from being active. Like, for example, Monero. Monero is untraceable still, and there is no much like logic in tracing it. There is some efforts happening. I've seen the studies from United States. We're trying to apply the same things we've been doing with Tor chain for internet. But it's not so much applicable, let's say so. And how we fight it, we just made it unusable for big crime and big money laundering. So you can send $3,000 in Monero for somebody to make pictures of things you're interested in another country, for espionage or for anything. But you cannot wash millions or billions of dollars in Monero, because there is not so much value locked inside of this chain, or at least your move will be so obvious that there will be no need to even invent anything to trace Monero. So that's why for big things, Monero is unusable. It's a small crime stuff. And we want the Garantex to be a small stuff, but it's not small, it's huge. And I would say even enormous. Like, as I said, it's 5 times bigger. And the problematic of this is simple. Why is it happening? Is it happening, first of all, because the Garantex aware about how ML provider works. He's been using ML providers for years, and maybe still using some ML providers, never told you that. But they know how they work, and they know the limitations, the technical limitations and legal limitations, because sometimes we can have a very, very, very strong guess about something, but we will not be able to place it inside of our software. The reason for that is we already have a precedent, I don't know, for now, I'm more saying like, unfortunately, Chainalysis is in the court for $650 million case because they say falsely accused, but they actually labeled somebody as a scam project. They was not even making a big deal about it, but the project itself estimating that the losses he took from being falsely claimed as a scam project is reaching $650 million. So which means that you need to carry about your attribution even more. And some companies been so shocked about it that they went out of the market. So for me, it was a surprise that the company of 5 people in 2019, that how much of us it was, actually works longer than somebody who was created by MasterCard, for example. That shows that money is not everything. And if you have a proper methodology in place, you can, I wouldn't say I would play, because I wish all the best to MasterCard, and I know that they will get back on the market with way better database. But still, there is a way to do things properly, let's say so. So the guarantors, they mix the funds. Imagine, usually we have a hot wallet, operational wallet. So the operational wallet, that is like one wallet and you use it, few wallets and you use it for years sometimes. And for Garantex's case, that's only one of the hundreds schemes they are using. And this one is showing that they are moving their operational wallets through single-use wallets every 1 or 3 days, which is a complication for us to trace and update this stuff. Thankfully, we have automated updates and everything. But for you guys, imagine you're getting the subpoena for the specific wallet because you want to block it or you want to withdraw funds from it. Me and you knows that 3 days, it's very long sometimes. I mean, like it will take longer. It will take longer than 1 day for sure. At least you will do it in the evening and you will act in the morning, and then you need to send this subpoena to the, I don't know, to the token holder or to the business itself. In this case, it's more like token holder. And while you're doing this, they're already moving. So you need to have a new subpoena, a new subpoena, a new subpoena. Also, people are easily corrupted. And of course, if you have so much money, some people can be corrupted. And sometimes we're doing the subpoena, and for some unspeakable reasons, the wallet moves instantly right after the people were trying to get subpoena from receive this information. So those things unfortunately exist across every jurisdiction still. And to wrap it up, let me show you how the very small investigation can be done in 1 minute to ease the job of everybody who is in here. 1 second. I will change the share screen. So I have all the wallets that I'm interested in and monitoring. So in real time, I see everything that is changing. If I have investigation cases, then I'm watching the money of everybody automatically. If I'm a compliance officer, then I'm going to be overlooking my own structure of wallets. So I see that everything is fine, no new reports is done. Let's check this one. Since it's Ukraine, kind of like a lot of people from Ukraine, so the case will be also like pro-Ukraine. In this case, this wallet started in 2022. I think I don't even need to tell you the exact date because you know it, and it's belonging to the coordination center of Novorossiya. So first of all, the second thing that is making us to stand separately a little bit from every other, that everything we have in our software is admissible. So in this case scenario, for example, you don't even need to ask us like, Vlad, where you got this label from, please tell us because we're in the card. No, you will have it right in the app. So they have their own Telegram channel and they themselves posted this. A lot of those same thing happening with politically exposed person, because usually politically exposed person, they're trying to collect funds for some politics they're trying to do, or initiatives like, I don't believe in COVID, send me money here. Like, I want to separate, send me money here. Or government is after me, send me money here, I need to buy McDonald's or something. So we will be watching this, and that will be a proof for you to use in court. And of course, we can support it with way more data on top. So I have this wallet. Of course, we can see everything that it was touching in any form. Is it direct? Is it indirect? Who is standing behind it? Who is speaking to who? Where they got? Where they go? But the interesting stuff for us will be is that we also can visualize it. And let's visualize it and find somebody who we can send in prison for the next minute. So, for example, we have this wallet that is receiving illicit funds in our system, everything. I know some of you maybe remember the old court instruction that all the financial data need to be presented in the linear form, but it's not working. We have 100% standing in court. We will never be neglected for that reason. And I think it's the same kind of instruction as not shooting the, I don't know, bulls from second floors of wooden saloons. So for example, we have this. Let's see who is donating. We have the $700 donation. $700 seems like real, because everything under $1,000 is on the limit of the stupidity of some people to personally support somebody. Over 1,000, I will be mostly suspicioned as the part of financing from another side, let's say so. So now I'm sure. Okay, let's see who was giving money to this wallet. Okay. So we have Bybit, 2 accounts of Bybit been depositing funds to this wallet. And then in one step, it goes to Coordination Center of Novorossiya. You can imagine that it's a drugstore. You can imagine that there is like, I don't know, anything. So we done it, how much? In 1 minute. And we know that 2 wallets of Bybit are answering for this. So we already have a link. After that, the only thing the law enforcement need to do, of course, they need screenshots. They can save it in our app and But the main thing you need to know is, can you ask them questions at all? So you can click on every business or every entity, every attribution we have in our system and see, first of all, do they require QAC? Do they collect this data? Where do they say they are registered? What is their real name? All the social networks they have. Traffic analysis, even the screenshotted version of the website if VPN is not working for you. And then the important things for us, we need to see where they hold the license, because the world is like this right now. One day countries answering us, another day they have I don't know, bad news that Ukraine is actually losing, so they will not answer us. Next day Ukraine is strong again and they will get Moscow, I don't know, and then everybody is answering us. So you need to watch out what kind of registration do they have. And if those countries, those jurisdictions are friendly to you, then you have a very, very higher chance to receive an answer. But if it's unfriendly jurisdiction, then your chances go closer to 0. And that's the same reason why Ukraine needs the, how do you call it, the license procedure, because as soon as we will do it, every business who operates within Ukraine, and in before war it was 8 billion going through Ukraine, then we will be able to ask them through our authorities, because they will be scared to lose a license in Ukraine, and that will be, it will make the process way, way faster. The same thing applies, of course, to every another jurisdiction. And after that, the only thing they need to do, either they see the person, maybe they're in contact with, but mostly if they're going from the streets, let's say so, they will just click on government and law enforcement, and everything they screenshotted, like the data they collected in before, will be sent here. In case if it's complicated and you need our help, then we will do it on our side. And then we will form a case, it's anonymized case, and not giving up anybody. So we will do it, all the introduction, all the visualization. And because the activity that we are doing is not licensed for now or certified, so there is no like certified IML provider that can provide expertise in court, and then there is those that cannot. No, there is only one, like, let's say, so common sense thing that segregates, like, let's say, like 6-7 companies from everybody else, that we collect our own data and we can answer for it, because if you're buying it from somebody, you cannot answer for it, obviously. And for the judge, we need to prove a few things. We do integrity statement in which, A, we showcase the specific person within the company and his experience. So who's done it? If there's mistakes, then jokes on him. Second, who are we that we're part of an organization? Who is our client? So for example, like if Interpol, Europol works with us, FATF works with us, trust us, then why, I don't know, the judge from some small city or not small city will have anything against it, so he will need to fight more, let's say so. And of course, we're proving all the logistics. So beside labels, the wallets, the things was going through A, B, C. We just need to prove that we're proving the person who done it. We're proving our expertise, why we know who is standing behind A and C, for example. And then we need to prove through the blockchain data, which is the easiest part, that the money was actually going through wallets A, B, and C. And then it's done, as well as my presentation.
Thank you, Vladislav. Thank you very much for your presentation. And we have also one participator, but without presentation, with some question. Just joined to us before Vladislav's speech. Basil Maniosos, international level expert and forensic expert in cybersecurity, well known in Scotland and in around the world as a cyber expert for Interpol project. So Basil, you hear me?
Yes, I can hear you.
I want to invite you to discussion with Vladislav, because you are both working as a cyber expert, but Vladislav is expert in crypto part of cyber forensic. You are most working with data experience, but you have more than 20 years, as I remember, experience as a code expert. Maybe you have some question or ideas about how where difference in crypto investigation and expert opinion between standard data resources and expert opinion. It's standard procedure.
Thank you very much, Alexander, for inviting me, and nice to see you, Vlad, twice in 24 hours. Excuse me, but I was running a 24-hour marathon and had been here a lot.
I just told to our participator about your famous annual marathon 24 hours about crypto. Cyber forensic. It's really for professional, but your network around all world. That's why you have speakers from all times lines from all countries.
I was very lucky to have great speakers during the marathon, and Vlad was a great addition. So yes, Vlad and I, we are doing different work, but it also has a lot of similarities. We both work on evidence. We're looking at evidence at the end of the day, and that evidence is needed to take a case in court to prove a point. For me, you know, being in forensics is like a medical examiner. Is after somebody has died, the medical examiner goes in, the coroner goes in, and try to explain why that person died, or you know how the crime happened. There's a big difference in the sense that forensic examination of data coming from cryptocurrencies and coming from blockchains are totally different to the analysis of static evidence that you have on a mobile phone or a computer drive. And one of the big difference is that you are looking at the evidence away from a device. You're not looking into a device, a mobile phone or something like that. You're looking into a ledger, and you need to be able to understand. And not a lot of people actually understand how ledgers really work. I was working at the university, at Napier University, and I can tell you, you know, everyone in the blockchain lab, you know, was way better than I was. Forensic investigations of ledgers have one positive thing, is that most of the time you can keep the ledger as it was. You know, it will not change. You know, if someone wants to alter the evidence, they cannot do it, and they can, even if they manage to do it on their own device or their own copy of the ledger, it will not happen in other copies of the ledger. And this actually gives you the opportunity to see, okay, if there is a deviation, if there is something that's not matching, then something is wrong there. Okay. The other thing is that when it comes to digital evidence, it has taken many years for lawyers and judges to, and of course, jurors to understand the basic elements of digital evidence. So trying to explain to them concepts that even other forensic experts cannot easily understand is going to be a big problem. That's why so far, the majority of the cases that involve cryptocurrency or blockchain are civil cases rather than criminal, because in civil cases you have lawyers who keep getting paid and the lawyers who have the time to go around the evidence and understand it. Where in criminal cases, usually you don't have this luxury. One other thing is that you will easily find in investigations like that, you are going to find, how do you call it, that people do stupid things. People think that if you are paying with Bitcoin, nobody will ever know what you did, and eventually, someone like Vlad will come around and prove them wrong. And you can count on people's ignorance and stupidity to trace things back.
But
I don't know. It's sorry.
Maybe now itself we told about this. It's difficult to find the real criminals. Also, I show one example when artificial intellect system that verified customers in exchanges now sometimes working with another criminal artificial intellect who create artificial person for verification, and also they use and they create unreal biometric data from unreal person. Now it's just fighting one artificial intellect with another artificial intellect. They fight with this, and sometimes in the crypto crimes we cannot find criminals. And Oleg just told about this. That's why English law better for dispute resolution. Of course, not a criminal, because you can use English law for returning your asset without finding criminals. Without you just need to show to the court that it's my property, just return my property and use a court order, in international court order for international WASP crypto exchanges. But for my opinion, main challenge now for lawyers with crypto investigations and for judges and for advocates, maybe 2-3 years later, it will be wide access for blockchain code and all. Now we can read everything and translate everything using our Explorer. But now we have Blockchain Explorer, and you can change sometimes wallets of your partner, and it's dark, or you can use cheap or free access for some program like MLBot or Global Ledger, for example, for check and verify your counterpart. And now maybe we can use some experience and trainee judges, prosecutor, investigator, how work with these explorers and how verify evidence in these types. Because for example, in Ukraine, in bank cases, now judges ask, guys, we don't need any expert opinion about calculation mortgage rent, for example. I have a calculator. I can calculate it. So maybe 1 year or 2 years after, all judges in criminal cases or civil cases with crypto assets can use Global Ledger program after some courses by Vlad and open wallet and find this asset and verify evidence that we can show this. Basil, maybe our job as lawyers and experts will finish it after this progress. What do you think?
No, I don't think so. First of all, I think it's a bad idea for lawyers and judges to do the job of experts, because they are not experts. They need the expertise. When someone is working on the field for 15 or 20 or 25 years, ChatGPT or a tool that the judge is going to have on their laptop is not going to replace that. The same way that, for example, I'm an expert witness. I cannot just go and do the job of a judge. I cannot sit in the judge's seat and just, put ChatGPT in front of me and decide, how to run the courtroom. There is a need for training, and one of the things that I saw with Interpol, I was part of a project called Project Leader, and they want to create a capacity for 8 Southeast Asian countries. And part of the program was to educate prosecutors, because the very, very important issue when it comes to digital evidence and criminal cases is not mainly the police, it's the prosecutors, it's the people who do not understand what the police says. And in Scotland, it has gone so bad that when I started 15 years ago, both the police and the prosecutors were really bad. The police is now much better. I can see it, and it's harder for me to find mistakes in the police reports. And now I go to court and I actually agree with the police to make the case for the defense. And I say, well, here's the thing. I agree with the police, and, the police never said what you claim. The police report never supported the things that you put into the charges. Germany has specialist prosecutors. They don't have specialist judges yet, but they have specialist prosecutors, and they have cybercrime prosecutors. I've worked with one of them. They have a team of digital forensic experts, and they are doing fine. Okay, they support other smaller prosecutors. They support judges. They are doing what they're supposed to do. And this is a very interesting concept. We need to start by having specialist prosecutors, and then we need to train lawyers who want to be trained into that, so that they can understand especially in the civil cases, they can understand what their expert is telling them. The legal profession used to be totally isolated. You study, you get your law degree, and you study law, and you specialize in English law, and nothing else exists except for English law. Okay, that's not the world we're living. Okay, a Bitcoin can be anywhere. A transaction, an exchange can be anywhere on the world. Okay, and it's not always going to be, black and white when you try to recover assets through legal processes. You need to have specialists in the legal profession, both as prosecutors and both as lawyers. And maybe at some point we need to have specialist judges. Okay,
maybe civil and criminal specialization. Maybe our participators have some question for Basil for finalize our conference. And any question in chat? So let's thank you for all our participators. Basil, thank you. You are always support us and finalize our conference few
My
years.
pleasure.
Yeah,
My
and
pleasure.
it was also your idea join Ukrainian academia and private advocates and experts for Cyber Scotland Week last year. So we have today second conference, and maybe little tradition. So I should mention it. Our organizer and our who support our conference, it's State Institute of Economic and Legal Research of National Academy of Science of Ukraine, named by Valentin Mamutov, and the National Bar Association of Ukraine, Ukraine Modern Digital Science, the Clark Foundation of Legal Education Scotland, who support our event between Scotland and Ukraine as well, and International Association for Artificial Intellect, Ethics and Integrity. Thank you very much for all. Thank you who answered for our call for papers. Articles and will be available maybe 2 or 3 weeks later, or sent to all email that you use and under registration. Thank you, and read all our news in our webpage in Institute of Economical Legal Research and the Ukrainian National Bar Association about our next meeting. Thank you. Thank you very much, and see you next year on our next conference.
Thank you for inviting me.
Thank you. Thank you. See you.
Bye-bye, guys.